Boom. Hey, folks. I hope everyone is having a happy Wednesday, if that's even a thing. Now, today was a short day in the Uvalde trial. And I say that it was a short day because originally the plan was for them to have a half day. They were going to have witnesses and so forth, but there was some medical appointment. I'm not sure if it was the judge or a witness, one of the lawyers, somebody had a medical appointment, and that medical appointment was going to make it a half day. But then there was an issue with disclosure, and so that resulted in today being devoted to that. Yesterday, the judge was like, so, jury, come back Thursday because we got business to take care of, and it's going to take all of tomorrow. So y'all can come back when that's done. So that's what was going on today. Now, it didn't actually take as much time as all that. The court recording is 53 minutes and 52 seconds long, but the court recording is also mostly break. They spend a lot of today not being in court, and so notwithstanding the fact that it's that it's a shorter day, it's an even shorter day. So we're going to cover what happens, and spoiler alert, the judge does not grant a mistrial with prejudice, does not grant a mistrial without prejudice, but for remedies, we'll see. So the remedies are left to be determined, and we're going to see why. It's actually an interesting strategic decision by the defense. I don't hate it. I think the defense is doing something interesting. So we're going to watch that, and then we're going to go, and we're not going to watch the entire Kouri Richins hearings for the day because they were long, but I do want to talk about one issue that came up because it really hits my particular peccadillos, which is bad experts. And there's a really apparently shitty expert that they want to call in the Kouri Richins case, and the defense doesn't want it. And so, yeah. We can also talk about this briefly. What's your take on Alan Jackson stepping down as Nick Reiner's lawyer? We can talk about that real quickly. So if you didn't catch this, it's been announced that Alan Jackson, who was Nick Reiner's lawyer, who is, of course, accused of killing his parents, has dropped out of the case and has said, I'm out. He's going to have to get a public defender. Now, there's two real possibilities. One possibility that's been advanced, a lot of people say it must be some sort of conflict of interest. It must be that he's got a conflict and he can't pursue it. And I think that's less likely because Jackson said, listen, I've got to get off the file, but he's going to need a public defender after this. And so if the family was funding this, like if money was not the problem, but it was a conflict of interest, I would expect there to be something where Jackson is saying, I'm getting off the file, and here's the new guy, right? Here's the new person. Because, if I'm getting off the file and, I'm probably referring somebody, right? Like, here's this other guy, he'll help you out, right? That kind of thing. Whereas if you're getting off the file because of money, you're probably not referring another lawyer because that lawyer is equally not going to do the job for no money, right? It's just not really how that works. Nobody wants to do a job for free. So that'll be the thing. So I think that it's probably just that the family who was paying the bills might have said, hey, you know what? We're not paying the bills anymore. right? We're not going to do it. That's just, we don't feel like paying the bills. And so at that point, he's on his own, right? And I see people saying, how can the kid have a public defender when his family has so much money? His family, of course, is quite wealthy, being, Hollywood, etc. However, that doesn't mean he's got access to a single dime, because being that he's accused of killing his parents, he may well have no access to any of that money and no expectation of getting any of that money, right? Because if he's convicted of killing his parents, his inheritance is going to be zeros, right? Zero. So that's it. He may not be inheriting a single dime from all of this, right? So yeah, we'll see. Anyway, let's dive right in now to sort of refresh people's memory here as to what we're talking about. I guess before we dive in, we'll do a little refresher. This is a trial around the killings at Uvalde. Now, what this officer, Mr. Gonzales, is charged with basically cowardice. That's essentially what the charge is. It is child endangerment by failing to engage with the gunman, failing to shoot at him, failing to go in and do those things. And they're saying that by doing so, he endangered the children. And yeah, he's facing somewhere around 50 years total as a possible maximum sentence. I forget how many counts it is, but it's like 2 years a count. So he's facing a potential serious issue. But yeah, essentially the charge is cowardice. And so what happened last week was they had a witness who suddenly indicated for the first time that she had seen the shooter. And this apparently was never testified to before. It's new information. And this really messes with the defense, because the defense has this whole timeline down to the second of where the shooter is, and importantly, where their client isn't, which isn't seeing the shooter at any point, right? And so that is that's a big deal. And the defense is going, they're ambushing us because this is information we are finding out for the first time ever right at this, right at this hearing. And so they've accused the prosecution of, basically of, sandbagging them. And they have said, listen, this is not appropriate, and we want a mistrial. Now, whether they get their mistrial is, we'll see. So far, the judge is not having it. So, and I'll just put out another tweet there, just going live now. Come join us. All right. So that's what they set aside today to deal with. And yeah, let's watch. I suppose it'll work better if I actually pull it up. I was like, let's watch. And then I was like, oh, right, you guys can't see it. So here we go. And there we go. Okay, here we go. And if you can't hear anything, it's because there's no noises yet. We're just waiting for them to all get ready. They spend a lot of time farting around on their phone before things actually start.
And Maria Chavez.
Okay, here we go.
Exhibit A. I did not file it because with the filing system, and there's our defense strategy, what you asked for. I would just ask,
it'll be sealed.
File it, but you asked that it be sealed after you.
Yeah, it'll be sealed.
Thank you.
And you had your notes, Ms. Mitchell?
The record reflects that I'm tendering to the court my notes, all of my notes.
So, did you just catch that? The prosecutor says, I am tendering to the court all of my notes. All of my notes. And, yeah, it's going to be interesting. So,
The court, my notes on witness Aaron Robin and Maria Chavez, who are also teachers that would be located on the south end of the building.
the number of times I have given a judge my notes is 0. Yeah, it's a 0. So, yeah.
Okay, these also were tendered to me in camera, so they'll be sealed as well after I review them.
Yeah, no kidding. They're obviously going to be sealed because, yeah, there's no way they're revealing all of that. So, yeah.
I just wanted to also clarify for the record, Your Honor. So yesterday when I testified, after I testified, I, off the record, told opposing counsel, and I want to put this on the record, that I had not reviewed Stephanie Hale's interview with the Rangers at the time that she appeared for trial preparation. I went back to my notes. We interviewed her on December the 10th. At that time, I had not reviewed her testimony to the Rangers. It wasn't until the week of Christmas, I think all around December 26th, is when I started pulling the witness interviews with the Rangers that I reviewed for actual testimony to the Rangers. So the position that I should have had an epiphany on December the 10th when we interviewed her in anticipation of trial is misplaced, and I just wanted to make sure that that was on the record to clarify.
Yes, Your Honor, and our position on that would have been the epiphany should have occurred on the 26th when she reviewed it.
Okay. Okay, well, I'm going to review these documents that have been tendered to me in camera, but I will obviously at this point take any motions or arguments as far as remedies or proceedings in this matter. So, defense?
Yes, Your Honor. So as the court will see from what's been tendered as far as our defensive strategy, this situation did have a significant effect on the strategy from voir dire all the way through and through future witnesses, should they be called. We're in a position where we know under the law that we have to ask the court for a mistrial to preserve the record. However, if the court was not inclined to grant a mistrial, we do have other remedies we'd like to discuss.
So basically they're saying we are asking for a mistrial because if we don't ask for a mistrial, we screw up. We don't get one. And so he's like, but we know we need to ask for other remedies. The reason why they're coming back with, but we have other remedies that we can, that we can ask for is because they know they're not getting the mistrial, right? You know that on a trial like this, to get the mistrial with prejudice, it's got to be a huge deal, right? They're not going to do, and I mean, even more so than Baldwin, because with Baldwin, the court was reluctant to grant a mistrial with various, sort of allegations of shenanigans. But here, it's even bigger because this is the Uvalde case, right? That entire gallery back there is like victims' families. It is, and so a judge has got to be, they're going to be really reluctant to basically say, okay, I'm going to pull the plug on this in front of a gallery that is full of the victims' families, right? And I mean, that's just realpolitik here, right? It's just, quite frankly, as much as we say that judges are high-minded and above that, and that it will never affect their decision-making, of course it affects their decision-making. Of course it affects their, their thinking on that one. And, yeah, I just, judges got to be, it's got to, they're going to have to wear an asbestos suit if they do something like that. So, and I just started a goal for Runkle, have a drink of, I've got plum wine here. So, all right. If you feel like chipping into that, then awesome. All right, here we go.
Well, let me just say this, under Heath, the greatly awaited case from the Court of Criminal Appeals about the court's discretion and power to basically, if there is a Brady violation or a Morton violation, to have the ability to exclude that testimony. And they clarified that the prosecutors, it does not have to be an intentional act. And I'll say for the record that I find, based upon what we heard yesterday, that this was not an intentional act. At best, it was a negligent act, or at worst.
So the finding that it's not intentional really undercuts a request for a mistrial, right? So he's saying, okay, they might have screwed up, but they didn't mean to fuck you. They just accidentally did so, right? And intention does play a lot of role on this, because if they intentionally are withholding things, then it's going to be a big thing there. Somebody says, I see Runkle is also on X tonight. Hello, Runkle on X tonight. Hello. And if you're watching on Twitter, I encourage you to join me on YouTube, because quite frankly, Twitter pays nothing. So feel free to join me on YouTube if you're inclined. But yeah, and please share this out. Please like the video, all of those good things. So, and we'll be doing the recaps every night until this trial is done. So
I do have the remedies under Heath available, but if you're making your motion for mistrial, I will tell you, I don't believe what I've heard so far without reading although I have summarized what you gave me, and I kind of already had an idea of what it was. So I guess my question is, since we talked about yesterday, the three things that were complained about was the puffing, her seeing the dirt being puffed up. Number two, identifying or saying that she saw the individual for the first time, and the location. All right, my question is on the location issue that she testified to yesterday, and frankly, I think that was kind of a very quick testimony. I'm not sure that it resonated with the jury, but my question is there going to be other witnesses that put that individual in the same location that are going to be called later by the state?
Your Honor, I would say the most probably compelling testimony are the casings in the case that the corroborator override what she said. I believe the location that she placed, she's from probably in the neighborhood of 100 yards away, looking toward the south end of the building. And she puts, I believe she marked, in a general area south of the building, the casings are going to be closer toward the west side of the building. That is, they're going to be further west by as much as 10 yards. I haven't figured the exact date. So a witness from 100 yards away, placing a witness within a 10-yard distance, that would be the distinction. The other.
Now, I mean, there's a difference between somebody seeing something at a place at a particular time, because part of the argument the defense is making is that they never saw each other, and so when the guy was there ends up mattering, as opposed to just that he was there. So I don't know that this argument from the prosecution really holds to me, but okay, that's what he's doing.
Potential witness, Noni Flores. Noni Flores testified that, would testify that the gunman, as she saw the children go into the south door, she saw the gunman at the south and west corner of the building, which I believe her testimony will put it halfway between where the casings were and where this witness says it was.
Okay. Well, I did a little research last evening, and again, I don't want to. I've reviewed your in-camera explanation of how this affects your defense strategy, and I'd already.
The reason why there'd be an in-camera explanation about the defense strategy is, quite frankly, the defense strategy is, super, it's like super confidential. It's super classified, to the extent that, like, if I accidentally gave, the prosecution a binder that had my defense strategy on this, then that would be, like, they would have an obligation not to use it, right? They would have an obligation not to look at it. So, like, if I was like, oh yeah, the pictures are in here, and I hand them the wrong binder, and the prosecution opens it up and they see my trial notes, they would have an immediate obligation to close that, give it back, and say, hey, I saw your notes. I'm sorry. I didn't mean to do it. So it's very uncommon that the judge gets looped in on the defense strategy, which to my mind is just like, wow, okay. This trial is already one for the history books, just in terms of, like, the weird stuff going on so far. So, yeah.
Kind of gleaned what it was. So I can tell you, I'm going to deny the motion for mistrial. You have made it, and you've preserved your record. Again,
Yes, sir. In addition, can I just, so I can make sure it's clear, because we all know how the courts start interpreting it later. We will go with whatever remedy the court decides that we can decide it. However, we do not believe that it's a sufficient remedy, and mistrial would be the only.
Yeah,
So the U.S. appeal system, basically, you've got to preserve your objections for an appeal. And so a lot of it ends up with this, like, artificial, like, back and forth here, where they're like, we will accept some lesser remedy because we, of course, want some lesser remedy if you're not going to give us the mistrial. But we want to preserve that we're not agreeing that that's sufficient. We're not allowing this to. So basically what they're saying is, if you give some other remedy here, like a jury instruction or whatever, we don't want an appeals court saying, well, you got your remedy, so you can't complain. So, yeah.
Again, I'm going to deny the motion for mistrial over your objection, obviously. And I'm going to find under Heath, although it's not a prerequisite, that it was not intentional by the district attorney's office. It was negligent. And I don't believe what was testified to in front of the jury resonated enough to significantly affect your trial strategy. But what I
You hear that? He's like, the jury wasn't even listening, guys. Like, the jury hasn't figured out the problem. Well, do you think the prosecution is going to hint towards it? And, like, it is, to me, wild that he's saying, well, the jury doesn't understand the problem because, yeah, I don't get it. So, okay. All right. So yes, this isn't the SRO from this school. This is an SRO from a different school, and he's accused of not running to face the attacker. So yeah,
am going to do under Heath is I'm going to exclude her testimony.
We have just before you do that, really, I just want to know we have a response to if you would consider that. So.
We would also have a response to that, and just so we can explain to the court that.
So the judge is like, I'm going to exclude her testimony. I'm going to kick her out of this trial. Basically, like, anything she said is out. And the defense is like, wait a minute. Are you fucking kidding me? Well, yeah, let's.
Our primary concern with an exclusion is that basically what's happened, and I understand the jury and you'll instruct the jury to disregard. I think a lot of that testimony, though, is going to be difficult for them to disregard. A lot of it is emotional testimony.
So what the defense is saying is, listen, this is not a good remedy, because what you're doing is you're basically having this witness that they've heard. They heard the prosecution go through their direct. And then the prosecution is like, or then this problem comes up. They put it over to Thursday. The defense doesn't get to cross yet. And the judge is just going to say, okay, that witness that you heard from last time, ignore everything they said. Well, the jury isn't going to be able to ignore everything they said. So what it basically means is that this witness would go without cross-examination. And, and then the jury is told, like, just ignore it. And it's like, judge, you just gave them a free witness with no cross. Are you kidding me? Like, I don't know that that's helping, Judge. You might actually be like helpfully setting fire to our car here. So I think he's, yeah.
The things that we were thinking about as a remedy would be to allow us to play her statement to the Rangers in its entirety to the jury, so that they can hear what she said in the first 4 days.
Well, I was going to give the option of, even if I exclude her testimony, you still, if you wish, could cross-examine her and do that.
Okay.
And then at the conclusion of that, my thought could be to exclude it at that time.
Yeah, sure.
And the judge is like, okay, so here's what I'm going to let you do. I'm going to let you finish the cross. You can go through all of that. And then afterwards, once you're done with that, I can tell the jury, ignore everything she said. I'm throwing her out. That's a better remedy from the defense perspective, because at least they get to show the jury, hey, we think this witness sucks. So, yeah.
It's not, because I guess my concern would be if we excluded it now and they haven't had an opportunity for.
I was going to give you that choice, but you jumped ahead of me.
Sorry, Judge. I'm sorry. I got.
The judge is like, let me finish. I was going to give you everything you wanted, but yeah.
I'm a little afraid. I'm sorry.
All right, Ms. Mitchell, what do you have?
Your Honor, we just have a stage response to the defendant's motion to exclude the testimony of witnesses SH in anticipation of their motion. So I just want to file that with the court for the court's consideration. If you could file stamp this copy too.
Okay, well,
And that's my copy.
Good.
The first copy is for the judge.
School resource officer.
okay, thank you.
I just want to file stamp copy.
Okay, so again, this is kind of a sua sponte remedy that I've devised. It's not really their motion. Did you file a written? Did you file something?
No.
Okay.
This is just anticipation of an oral motion to
Okay.
exclude, Your Honor.
Okay.
I don't know, Your Honor, can we confer as to possible remedies and see if we can come up with a solution? Would the court be open to that?
I mean,
She's like, can we come up with some remedy that doesn't actually give the defense anything? You see this a lot with prosecutors where they're like, how about a remedy where you just like, make some noises that don't mean anything? And yeah, it's a thing. So yeah.
if y'all agree on a remedy, I'm happy to entertain that, but I want the record to reflect that pursuant to Heath, I do have, discretion to craft a remedy any way I see fit. But what I've already done, for the record, is we have given a continuance to the defense until tomorrow, and we're having a hearing outside the presence of the jury to entertain potential remedies and make findings of fact if necessary. But for the record, there was a motion for mistrial, and on that motion for mistrial, I'm going to find it's denied because I think the remedies available are sufficient to protect the due process rights of the defendant. And if y'all want to agree on a remedy, I'm happy to entertain that, but I have one in mind, and I'm going to give the defense some leeway on how they want to proceed with the witness in front of the jury in the event she's recalled after we talk. So take 15 minutes, y'all talk, and we'll come back into court, and I'll review the state's response to the oral motion and finish the other in-camera matters that were submitted to me. But is there a place, if you want, just go back to my office. I'll stay here, and you can go back to the office that they've provided me.
We have a room actually that they've given us over here that's.
Or you can go, actually you can go to the jury room if you want to, because nobody's there.
He's like, you can go wherever you want. I'm surprised he's like letting them go in the jury room, because the next allegation that could come up is, hey, somebody left a note in the gym or something like that. So, or in the jury room, and now it's a problem. By the way, also hit the like button to acknowledge the stream. So yeah, let's, this is a weird result, right? This is such a weird thing here.
But I'm assuming that contemplates conferring that everybody goes. The state joins you. Okay. That's fine. All right. Well, y'all let me know. We'll be in recess till you come back.
So then they go off the record for a lengthy period to come back and argue remedies. So
Okay, she's ready.
I like how few F's this judge seems to give. He's like, I mean, he's not a bad judge. I haven't seen him make any like really awful calls or anything like that, but he seems like he just doesn't give a shit. And I think that's kind of appropriate. Like he isn't like getting all emotional or anything. He's just very much like, I can't fault his call. I can't fault any of the rulings I've seen so far. So I think he's doing pretty decently.
Have to report.
Judge, we've had pretty productive talks, and I believe, and correct me if I'm wrong on any of this, that the proposition at this point, with them still reserving the right to think of it overnight and start in the morning, is that they continue their cross-examination. They get to also play the entire statement that she made. We would then get to redirect, and then they still reserve the right to ask you to exclude all the testimony. And
yeah,
that part was all.
Yes, Judge, and under the idea that we want to unring the bell first before there's an instruction to exclude it, because and have them exclude it all in its entirety, which is fine. But we would like to be able to unring that bell and then make that decision. Depending on how that cross-examination goes, we might not ask to exclude her, because there are some things that she says that we're just trying to evaluate her testimony after it is to see on balance, is it more beneficial to our case or is it not? Like, after we've unrang the bell. But if we determine on balance that it's less beneficial, we would still like to have the Heath remedy for the late disclosure.
Well, for the record, I'm offering it right now. I'm offering the Heath remedy to exclude her testimony immediately. But if y'all want an opportunity to try this, if both sides agree, I'm happy to implement that.
So the judge is like, listen, I will throw this witness in the garbage right now. I will throw her out. I will we'll just 3-point it from the back right into the trash. And the reason why the judge is doing that, he's like, I'm also willing to let you do the cross. But if this, let's see if we can turn on closed captioning. There we go. Sorry about that. There we go. They're like, but the judge is like, I want it to be very clear. If this sucks, like if this turns out to be awful, then that's on you, right? It's your problem if this is, if this sucks. So I don't want to hear anything on appeal about how we gave you the wrong remedy because it's your call. And unring the bell. Is that possible? They are basically saying, listen, judge, we want a chance to put the poop back in the horse. And the judge is like, are you sure it's a horse? I don't think it works like that. And he's like, judge, we're going to give it our best shot. And the judge is like, you're going to get your teeth kicked out. So, yeah, it's an interesting step there. So.
Yes, Your Honor. What we believe is ultimately we believe we're asking the court to exclude. The only issue is that we just want to be able to unring the bell first.
All right.
Is the idea.
And I know I told her, but she's supposed to be here at 9:00 tomorrow. Okay.
Yes, Your Honor. Additionally, I will say that that in light of it, whatever harm that the court has determined in the defense case strategy or in emotional impact, we would add that, and we do believe that under our 403 motion and motion of limine under the autopsy photos and the like, that it would start to, that the court should add that in the 403 balance, because part of what was not disclosed is something that is, I guess, on an emotional level, especially in what this witness testified to has a tendency to prejudice the defendant. She was taking shots. She was actually personally traumatized by these things that we are going to show that she has never said before. But the jury, having heard that, we believe that it should be a part of the 403 balance when the court eventually, I know you haven't made your final decision.
They're like, judge, because of the prosecution's screw up here, one of the other things you need to do, one of the remedies you need to give us is you need to throw out those pictures of the dead children. And he made that argument before. He lost. And I think the reason why he, normally Mr. Goss is a very smooth speaker. He gets his, what he needs out. He's very direct. He's very whatever. And instead, here, he's kind of stammering through it and he's kind of meandering through it. And I think it's because he realizes this is a big ask and that the judge might yell at him. And I think that he's like, yeah, I know I'm asking for a bridge too far here, but I gotta try. So
about what it is, but I would just, for the record, I would say that it can compound the harm if there's a disclosure, and then the probative value, whatever that is, of them trying to get into these photos of these children, are the prejudicial danger is compounded by something like this occurring in the trial, as to how it can affect the jury. And so I just wanted to put on the record now, I know the court hadn't made the decision, but just to put that in the court's mind that we are also going to be arguing that at a later date.
All right.
And Judge, I just wanted to be clear because I originally heard the court say, I'm willing to strike all the testimony now, but I'm also willing to entertain the defense's claims.
I want on the record, because I've denied the mistrial, that in lieu of the mistrial, I'm ready to exclude the testimony now. But if you all want to agree on this, then I will implement your agreement.
Could you give me 1 minute then? I'll make sure.
The judge is like, I want to throw it out now, and the prosecutor's like, oh, we have to agree to this? Maybe we don't want to agree. Maybe we just want to take the witness with no cross. So now the prosecutor's like, oh, I got to think about this.
And I guess yes, I think just the court understanding, willing to strike now would the only reason we're not accepting that. What I don't want to do is be in a situation where I'm on the record saying that I don't want that court's remedy, because then the courts later will say, well, then if you didn't want the court's remedy, then how can you claim that the mistrial was wrongfully denied, right? So what I want to do is just say that the reason we don't believe that striking it now, and like she just goes away, is that we'll never have an opportunity to unring the bell.
And we think that the court's remedy of striking it all now is sufficient.
And now the prosecutor's like, don't let them cross, Judge. Don't give it to them. This prosecutor is he's backpedaling real fast. So that was something to watch, right?
Right. You see what I mean? And so what it does is it puts us in a situation where that remedy could actually harm our client worse. By
Well, all right. Well, we'll let the defense proceed as we just discussed, and she needs to be here at 9:00 in the morning, and then I'll make a decision on exclusion with everybody's participation after we rest and or actually she's finished with redirect and recross, whatever the case may be.
Yes, Your Honor.
But my recollection is she's on cross now.
She is.
Okay.
We left off where I was refreshing her with her statement, and then that's when this issue came up, and so I would just continue with the cross-examination.
They passed her and she's on cross.
Yes, Your Honor.
Okay. All right. Very good. All right. So 9:00 tomorrow with the witness, and we will proceed at that time. Thank you very much. We'll be in recess.
And that's what happens. So I think it's really interesting how the prosecution goes from like, yeah, this is fine, to nope, we are we are switching, we're going back on this. This prosecutor is greasier than like 2 a.m. pizza. I mean, oh man, this prosecutor, he makes some choices. And you know what? If I was the prosecutor, I would just say, we believe that the defense is entitled to a remedy, and we are amenable to how the defense, we don't believe that a mistrial is the right remedy, but we are amenable to defense's procedure, because then they can't complain, right? Then they can't, like, prosecutor, you got the win by not getting the mistrial. Just let it go. But don't say you're okay with something and then turn around and not be okay with it, because that's a whole decision, and I don't like it. I don't like it at all. So let's read the super chats here. It's a bit of a slow day, but that is what it is. How many of your viewers are Canadian versus American? I think it's about a 50-50 split. So yeah, Jade, thank you for becoming a member. Bliberal, thank you for the 5 gifted memberships. Vez from Quebec says, never tasted plum wine. I'm drinking a delicious gluten-free Ghost Lime beer. So there's various forms of plum wine. There's various like flavors of it, but it's good stuff. I recommend it. So, hi, Runkle. Asked about your Patreon yesterday. Ever thought of opening a float plane channel from Linus Tech Tips over in Vancouver? I haven't, but maybe I should. I'll have to see if there's a way to, Honk Banana No says, rolling in late because I was watching Fallout, and I'm not even sorry. Anyway, goal and Honk Banana No. Thanks for your coverage, Runkle. Thank you. I thought something was off. Ian's in the wrong corner. I'm in the wrong corner because there's useful text in the left-hand corner. So I was covering up the useful part. Hope you like the plum wine. I don't think we're going to hit that goal. Elf Wiggins says, I like plums. Yes. Do a poll on US versus Canada. I guess we could do that. Whoop. All right. Here. Goal ended. We'll start another goal for the same thing. And here we go. How do I do a poll. Start a poll. Where are you from? Canada, US, add option, other Europe, and then other rest of world. It only lets me do 4 options if I recall, so that's how we're splitting it up. There we go. Canada, US, other Europe, other rest of world. So, all right. Yeah, and I suppose it's where you watching from as opposed to where you like born or whatever. But all right, let's go over to Kouri Richins, because Kouri Richins has a really interesting thing there with an interesting expert that the defense wants to keep out and the prosecution wants to use. And I was watching this and I was like, wait a minute, this cannot be as this can't be as bad as the defense is making this seem. And yet it is actually worse than the defense makes it seem, because, oh my God, when you actually see the experts and so forth, it's like, wow, that's a whole choice. Now, for some reason, when I do this, why? No, I don't want the... I'm trying to do full screen. It's like, hey, here's chat, but it just shows chat is disabled. Why are you showing me chat is disabled? I don't want chat. Stop it. All right, let's try refreshing it. Maybe it'll... All right, here we go. Let's watch this one. So if you're not familiar with the Kouri Richins case, Kouri Richins is this person right here, and she is accused of poisoning her husband with fentanyl. So basically, she made him a Moscow Mule, which Moscow Mule is a great drink. I like a Moscow Mule. If you are sitting there, like if you see me in a bar and you feel like sending me a drink, a Moscow Mule isn't a bad choice. Although a London Mule is an even better drink. London Mule is like a Moscow Mule, except it's made with gin instead of vodka. And if you're not familiar with a mule, it is like, vodka or gin or whatever. They make it with different things, with ginger beer and lime juice. And yeah. So anyway, she is alleged to have, have poisoned him to death with fentanyl. And yeah, so there's 2 experts that they want to bring in. One of them is a handwriting expert. That's not the one that I am as concerned about. The other one that I'm more concerned about is is this behavior pattern expert. By the by, somebody said, I thought you'd like a Caesar. Safe drinks I like. London Mule is good. Dark and Stormy is good. I like a Mojito. Caesars are great. Paper Planes are great. Those are all good choices. So, all right, here we go. Oh, yes. The other reason why this one got so much attention was because not only is she accused of killing him, but also she is accused of, or one of the things that happened afterwards is she wrote a kid's book about like overcoming grief for like kids. And the thing is like overcoming grief for kids is a perfectly good topic for a kid's book, but maybe less so if you murder dad, right? Yeah. So here's the thing. What you're going to see is a lot of evolutionary psych shit today. And I'm just going to note there is value to evolutionary psych, but the value to evolutionary psych has to be predictive. Instead, a lot of people bullshit up evolutionary psych and they do it backwards. So what they do is they basically come up with evolutionary theories for stuff we observe, and it drives me nuts. It drives me nuts, and quite frankly, I'm going to have some ranting to do when we get to that part. So
Court needs to hear it about the scientific reliability of the pathway to violence and why.
So the argument here, what the prosecution wants to do is they want to call an expert on the pathway to violence. And the pathway to violence is this theory about how these violent activities happen. And I'm being told it's still too quiet. We're going to try to noisen it further. One of the things is that whoever recorded this seems to have recorded it only on one audio channel. So we're going to crank the volume to see if we can, if we can actually hear this.
It should be excluded as under 702.
So let's talk about that structurally.
So she's saying, I want to throw this out because it is bullshit. It is bad science. It is craptacular. Throw it out. And that's a big ask because judges are reluctant to throw out experts, right? They are very reluctant to do that. And yeah. By the way, I can also tell you a little thing. Zora is pissed at me right now. Zora is mad at me. You know why Zora is mad at me? I have pizza crusts and Zora can't have them because she's too chunky. She's too chunky. This is not before the jury. The jury is out. So, yeah.
If I have one former FBI agent saying this is not the way we do it in the behavioral science realm, and I have another former FBI agent saying this is how we routinely do it in the behavioral science realm, doesn't that go to weight rather than...
No! Judge, you are supposed to be a judge. I mean, Judge, you are I'm sure you're a very nice person. I'm sure that, I have seen the chat talking about you in terms of your voice and, your look. And the chat basically is this. Yeah, this guy makes the chat super thirsty. But your job is to judge, and part of judging needs to be an understanding and analysis of experts, right? And so just because you have one expert saying one thing and a different expert saying another thing doesn't mean you just go, well, it's 1 and 1, so who gives a fuck? No, you need to do some actual analysis as to whether or not whether or not this is good as an approach. And I think that if you do actual analysis here, Judge, you would judgily turf this witness. And yeah. So it looks like for today's stream, we have 77% US, which I guess doesn't surprise me. We're covering US cases. I would love to be able to cover some Canadian cases. So, yeah. So, yeah, but he's just like, well, they're both former FBI agents, so they're just as good. I'm like, no, they are not just as good. One of them is actually good. The other one is actually crap. So,
admissibility?
Well, Possibly, but I think it might be more extreme than that. And that's why I think it's important we hear their testimony. From my understanding, that the pathway to violence has not been used particularly in courtrooms. And
So, can I cover Canadian cases, or is it super hard to get footage and shit? It is impossible to get footage and shit because they don't televise trials in Canada. So, yeah, it's impossible. I might do some Supreme Court coverage, and that might be something we start doing. So, yeah.
and doesn't come anywhere close to meeting the reliability standard under 702. And Dr. Fox, formerly when she worked for the FBI, also worked in this area and has a lot of information about how that study was conducted. And it could be a balancing act, but I actually think it might be such a huge difference that it would go to admissibility and not wait.
Okay. I have some questions for the state on Ms. Amon first.
May I just briefly address the court?
Sure.
Then Ms. Sherbernack will address Amon.
Okay.
Your Honor, because it's the state's belief that the defense has not even met its minimal requirements under Rule 12.
To do what?
That they specify sufficient legal and factual grounds for the motion. Now, even assuming the court disagrees with that, the papers sufficiently address the threshold showing. As the court is well aware.
Now, fun fact, this prosecutor is moonlighting from his usual job, which starts in around October, which is that he lives inside of a scarecrow and frightens children. But, yeah, it's, so this prosecutor's like, the defense hasn't shown that this witness needs to be thrown out. And yes, the audio is, the court sound is mono. I can't fix it. So, yeah.
After Ramash, after cases like Clopton and Gun Hill Dairy and the new Rule 702 flipped Ramash, which tended to keep a very narrow gate to allow very few witnesses through.
This might help.
It sort of flipped it upside down so it catches almost anything. And even if there's two witnesses who say the opposite thing, they can still come in under that new 702. And by virtue of the papers,
did that help the audio? Because what I tried to do is I put it on stereo repeat. And so hopefully, hopefully that's making it better. We'll see.
State believes it has met its burden of a threshold showing. Now, the court wishes to address specific issues. I just wanted to lay that groundwork. If the court has specific questions, we've got all our witnesses ready to go, as the court can tell. Mr. Throckmorton is here, and then the other two are on the line. So if the court wishes to proceed on to specific questions about Ms. Ammon, then Ms. Sherman can address that.
I appreciate the argument. The defendant's initial briefing was certainly sufficient enough for the state to file an opposition brief that had legal analysis, citation to cases, and consideration of the specifics of each witness's testimony. So the state's argument regarding the insufficiency of the defendant's initial briefing is respectfully rejected.
This judge is very polite. He's like, listen, the brief was more than sufficient. I could figure out what's there to argue, what's not there to argue. And so your argument that it's insufficient is go to hell. Politely. Is Zora as in Zelda? No, Zora is as per a Supreme Court case. on bail. And Zora is aptly named because that Supreme Court case was dealing with conditions and so forth. And she's aptly named because Zora is not able to follow any reasonable conditions and represents an unmanageable risk. So, yeah, Zora is very cute.
I have specific questions regarding each witness. Within the framework that you described, 702, and then if we're past 702, we have to deal with Rule 403, maybe. Whose witness is Ms. Amon? Ms. Sherman, I can ask you some questions.
Of course.
You just got to pull that mic closer to you. Okay. In its brief, in opposition to the defendant's motion to exclude Ms. Amon's testimony, on 2 occasions, and in bold print, the state says Ms. Amon may become helpful to the jury. Under what set of twists and turns at trial do you see Ms. Amon testifying? Is it in?
All right, so you already have the judge expressing a bit of skepticism here. The judge is like, under what set of twists and turns is this, and what is it? Yeah, it's a thing. Also, no need to disguise fentanyl. It has no taste. I am told that fentanyl does have a taste. The problem is that if you're getting enough fentanyl to be able to taste fentanyl, as opposed to like tasting binders or fillers or whatever else, but if you're getting enough fentanyl to taste fentanyl, you are almost certainly going to die. So, fentanyl is lethal at levels that that you cannot detect it. So, it is incredibly poisonous. So,
The state's case in chief, or only potentially in the state's rebuttal case, depending on the arguments and other testimony that comes in from the defense case?
The latter, Your Honor. It would be part of our rebuttal case, depending on what potential theories, evidence, witnesses come in through defendant's presentation.
And one of the examples the state gave was, forgive me,
I got to turn myself down. Okay.
in the state's view, Ms. Amon's testimony may be helpful to the trier of fact to rebut an
Let me know
argument
if
that,
that's
hey,
okay.
this doesn't happen like this. This is not the way violence gets committed. Wives and mothers don't suddenly kill their husband.
So what you hear here is the judge basically saying, and the judge is going to do this a lot. The judge is going to be like, so I have this certain specific scenario where this is relevant. And it really feels like this judge is a master at dividing babies, right? We always talk about, like, as lawyers, we talk about, the judge split the baby. The judge like divided up the, the what people wanted. And this judge is like, we are just going to slice this baby as fine as possible, such that I'm not denying this, I'm not denying this, but I am going to paint the prosecution into a corner where only if the, only if the defense makes a stupid argument will we then allow your. And so at the end of this, the defense is like, you're not excluding this witness. And the judge is like, nope. And they're like, but the witness can only come in if we do this stupid thing. And the judge is like, yep. They're like, okay. Because the prosecution gets painted into such a corner. Yes, I know, but that doesn't mean that that's how it has come into, into discussions.
And I understood the state to be saying, well, there's a progression here. People form this plan, unless it's the emotional pathway to violence. But this planned pathway to violence has a progression. It's been studied. This is how it works. Am I inferring the state's argument correctly?
In part,
Okay.
I think we don't know which theories, of course, defendant will put forth, but there are multiple theories that could come out at trial where Ms. Amon's testimony becomes relevant to assist the jury in placing the facts and evidence that they have heard into an
Brentwood Cheek,
analytical
thank you
framework.
so much.
And again, Ms. Amon's testimony, and I don't think this is clear from the defense's objection or from their reply, she is a blind expert. She will not be saying Ms. Richins, and also from the declaration from Dr. Fox, they seem to all miss the point that Molly Amon will not be saying Ms. Richins fits this profile, therefore she committed murder.
Right.
So blind expert, they mean they're not giving her the complete file, all of that. She's just going to come in to testify about generalities about how murders happen, as opposed to specifically opining about Kouri Richins. And we hit the goal. So I will show you guys briefly. This is the plum wine I got. It is not the best plum wine, but it's a plum wine. And yeah, it is lavender plum wine. So pour myself a little bit there. It is less alcohol than other things, but yeah, the volume of the trial gets louder when you talk over it. Okay, I don't know what the audio is doing, but we're trying to get through bad audio as best we can.
That's not the testimony. That's not what we would elicit. We agree that would be improper, and that's not our intention with Ms. Amon's testimony. It's more to assist the jury in a framework to understand how targeted violence occurs. Again,
Sometimes, right.
well, yes, but also Ms. Amon could describe that in every targeted act of violence, and this is part of her proffer, that there is a framework, a pathway to violence that perpetrators of targeted violence follow. Now,
Notice the use of the word every. That's a big word. I mean, it's a little word. It's a little tiny word, but it's a big word when you're, when you're using this. And thank you so much, Brentwood Cheek, for 20 gifted memberships. Much appreciated. What is it? Little Law Girl says, please let Zora have the pizza crust. She's a good girl and everyone deserves a cheat day. She wants every day to be cheat days. So, yeah, every is a big word here. She's like, every time. I don't think that's the case at all. And that's not what we're going to hear from the other expert.
do they complete a couple steps and
Set it
pause?
to all
Do they
comments,
follow the
not
same
just top.
timeline and the exact same sequence? Maybe not necessarily, but there is a framework of perpetrators of targeted violence who follow a pathway to the attack. And all of the targeted acts of violence that have been studied, the perpetrators follow this framework to some extent.
Okay. When you say all, you provoke some questions regarding the Diaz versus United States case that was cited in
Sure.
defendant's brief. Now, in fairness, that case has a holding that goes the other way, right? That said the expert there said, most cases it works like this. Most people that are transporting drugs know they're doing it. And the United States, a majority of the United States Supreme Court said, that's fine under Rule 704B. That's not a implication regarding the defendant's mental state or what was in there.
So here's the thing. When they're talking about drug trafficking, there are patterns that drug traffickers use, right? And it depends on which drugs are going down and so forth, but there's different patterns that you see. And so, like, one of the things you might say is, look, I'm a police officer. I've been doing this for, for 50 years. And, when I see this particular sign, it tells me drug trafficking. And so the sign might be something like, let's imagine you pull somebody over and you see that they've got a ton of Ziploc, or plastic baggies, like plastic sandwich bags in their car, right? And all of these plastic bags have the corners torn out, right? They're ripped out. And so the officer would say, look, I have been doing, policing for ages. I know that that's drug trafficker behavior because the drug dealers pour the drugs into the corner of the bag, and then they twist the bag off, and then that gets them a little one-shot thing that they can then sell to a person, and they use both bottom corners of the bag. He's like, I know this, right? Because I'm an expert in this. So all right. That seems reasonable, right? To say that this is drug trafficking behavior, etc. But that's a little different than when you're saying, here's the pattern here. This lawyer made me so mad today. Apparently, if you haven't been SA'd, there is no DV. The gaslight and victim shaming is disgusting. We could talk about things like that. I thought it was a bad example that they used. So, yeah.
Their mind, because it's most, not all. And is Ms. Amon in that bucket of blind experts, or is she going to say, no, this is how it works every time?
I think we would have to ask her that direct question. I mean, and she could explain to the court what her answer to that is and why. But I think to say all the time, always, is extreme. I don't think that's what Ms. Amon's testimony would be, but I would rather not speak for her. If that is in fact what her testimony would be, then we need to address that and explore it. But again, when we're talking about a retrospective analysis, which is part of what she's talking about in the studies of the pathway to violence, they know that these perpetrators have committed the ultimate act, right? They have perpetrated their attack. So that is a different analysis than to say, are there other folks who have started on the pathway to violence and not made it to the ultimate act, to the attack phase, if you will? Yes, those people exist, and Ms. Amon would not know who those people are.
I read her proffer. She seems to explicitly acknowledge that people stop at various points along the pathway.
That's my point. So to say that if you start on this pathway to violence, you ultimately will commit an attack regardless, all the time, always. No, that's not her testimony, and that's not factual. But for her to say, in all of these multitudes, decades of studies of people who have committed a targeted act of violence, we know the end result. The attack has occurred. We can place those folks on a pathway to violence. We can put them on these steps and identify the steps that they took to that attack.
Okay. All right. Hold on a second, Ms. Lewis. Anything else you wanted to say at this point, Ms. Sherman?
Not unless the court has additional questions on that point.
No, I understand the state's position. Ms. Lewis.
I just got to say, the kiss of death from a judge is, I understand your position. I understand your position is terrible to hear from a judge, because it does not mean I agree with you. It does not mean your argument is good. It means I've heard it, and I'm done hearing it. I don't need it to hear it anymore. And yeah, it's rough. Yeah, it's basically stop talking. I'm done listening. Do I think Runkle is a fan? I missed what I might be a fan of. So yeah, it's basically just you guys should stop talking because I have heard it. It's becoming repetitive, and yeah.
Well, Your Honor, listening to this, it might actually make more sense for Dr. Fox to go first. I understand the threshold is low. However, under Rule 702, the argument here is this is not generally accepted in the relevant expert community.
Doesn't need to be, though. That's one of two ways to survive 702B. If it's based upon a scientific method or sufficient education, training, and experience that's reliably applied to sufficient facts and data. But as a blind expert, she doesn't need to apply it at all.
I disagree. There's a case, first of all, yeah, the argument is that under 702. There's a case that is out of the Ninth Circuit that is directly on point, and it's
Cited in your brief.
no, because I didn't know about it.
Okay,
It's
can
something
you
I
give it to me?
just discovered.
That's okay.
Anyway, it is United States versus Wells. Let me give you the site. 879 F3rd 900. And that case was also a blind expert who is actually one of Ms. Amon's colleagues in writing the profile for violence. And his name is Dr. I don't know if it's Dr. Reed Malloy is the name of the expert, J.R. Malloy. And there's also, and yeah, I'm sorry, I actually just found this case yesterday. But there's also a 403 and 404B argument, because the way this works in courts, when they admit profile testimony, which the Ninth Circuit reversed and said this testimony comes in only very, very limited circumstances. They talk about how it's typically used in drug courier cases. This was a case, a homicide case, where Dr. Malloy was using.
So the drug courier case is one of the things they want to, one of the problems that you've got for a drug courier case is, so let's imagine you've got a situation where there's like a semi-truck, right? And the semi-truck has a cargo capacity of all the space, right? A semi-truck has like a huge cargo capacity. And so it gets pulled over. And in that semi-truck, when they search it, they find, they find like a jar of pure fentanyl. And, when it gets to its destination, it'll get cut down and so forth. But they can have huge, you can have a huge amount of like doses in a very small container. So, or let's say it's a crate, right? It's one crate of something. It's a crate of AK-47s, it's a crate of cocaine, whatever it is, right? So now you got a problem because you really want to send the driver of the truck to jail for like the rest of time. Because, they are smuggling a huge amount of whatever it is they're smuggling, right? So, the problem then is that you're like, how do we prove that this driver knew that the drugs were there as opposed to the driver being a patsy, a sucker, right? And so what they they get officers to testify that usually, most of the time, that the drivers know and are aware of the, are aware of the drugs or whatever else that they are bringing into, that they're transporting around. And that's usually the case, right? Because usually if you're going to be smuggling a crate of fentanyl or whatever else, you want the driver to know that that's the case and, whatever else. But not always. And so part of the way that happens, part of the way that goes is they use other signs, other symptom or other like indicators. So when the driver was pulled over, were they super nervous? When the driver was pulled over, were they, Did they resist the police? Did they run? Right? Did they, any of these things? Was the driver carrying a weapon? Any of these things might be a sign, right? So they can say, like, this, because most drivers are aware, and because this guy was terrified, of the police, he tried to run away. He, he was carrying a sawed-off shotgun. All of these things, you can say, well, this guy was aware. He needs to go to jail for the rest of time. So that's kind of the argument that they keep making analogies to, and I don't know that it's really an apposite analogy here. I think it's actually a bit of a problem analogy. So, yeah. I see people in the chat saying cheese is good, and I'm like, cheese is good.
The precursor to the profile for violence, has very much the same.
Also, I put a goal up for pizza bones for the doggos. I will basically take this. I'm going to divide it up so that Zora gets an end, like a little tiny piece at the end, and I'll give Potter the rest of the pizza crust, because Zora is too chunky, but maybe she can have a little tiny piece, and then Mrs. Runkle will be like, "Did you really?" And I'll be like, "Yes." So yes.
Criteria, it has been modified since then. This was in 2017, and he did a profile of killings in the workplace. He was a blind expert, although he admitted on the stand that he had reviewed the case at hand, although he didn't testify. He testified as a blind expert, although he admitted he had reviewed the case and the defendant. And the court ruled that this is improper character evidence, among other problems, because what happens is the profiler testifies that, so people who commit, in this case, workplace murder, have characteristics X, Y, and Z. And then other witnesses get on and say, well, the defendant had characteristic X, Y, and Z. So therefore, in conformity with that character, he committed the murder.
Yeah, but this is different than that. Like, I've looked at Ms. Ammon's proffer. She doesn't make it that specific. I'm sensitive to that concern. And certainly if she was saying, when we look at domestic violence, homicides, what we see are the following characteristics almost universally. She doesn't do anything like that. There's no level of that kind of specificity. She talks more high level in terms of initial grievance, inability to let it go, form of a plan. I may be missummarizing here, but there's a higher level to it. And when we look at Diaz is even more specific, and somehow a majority of the United States Supreme Court is like, they said most, not all. So the trier of fact can draw distinctions. How do I apply Diaz to Ms. Ammon's testimony to say she can't come in?
I haven't looked at Diaz in a while. I'm sorry.
Well, now's a good time to start.
I know it is, and I did not reread that case. So I would actually
We can we'll take a break at some point.
need
We
a
can
moment
compare.
to review that, to be frank.
Okay, Ms. Sherbanek.
Oh, I'm sorry.
Oh, good.
I do think that it would be helpful to hear Dr. Fox's testimony. For one thing, this routinely isn't used. It's used in BAU as an investigative technique sometimes,
right,
but it's not used in the courtroom. And that's because of all these problems that...
One of the things we're going to find out is that this expert has never testified before. So, yeah, it's a thing there. So
Dr. Fox is much more qualified to address than I am in terms of it's junk science is what it is. It's not scientific. It's not.
She is not wrong. Not wrong at all.
Used in the community, and I think that does stop it even under our low threshold here.
Well, hold on, but come back to the specific context of this case. The state has noticed Ms. Amon as a potential rebuttal expert, if necessary, to respond to an argument from a defense witness to the effect of, this is not the way it works. This allegation that Kouri Richins killed her husband is not credible because wives don't kill their husbands. People don't just snap and do this. That would seem to make this kind of explanation of how violent crimes are planned and executed helpful to the trier of fact under 702A to say, well, actually, based upon a retrospective study by the FBI Behavioral Science Unit, there is a pathway in which people do this. Full stop. And then the trier of fact can say this is within or without that body of cases. Tell me why that isn't allowable under Utah's Rule 702.
Well,
Now, first of all, if the defense doesn't make such an argument, then the state never calls Ms. Amon.
I think
So the judge has this like theory as to how this expert can come in, and it's very specific. So we're going to jump ahead a bit to when they actually like bring the expert in.
It's one person's opinion. There hasn't been a special agent in
you, and I know what's your experience with the FBI?
at USF, and I'm also.
All right, here we go.
Good morning.
Hi, good morning.
Okay. Sounds like you can hear us okay.
I can.
Let me turn on the video in the courtroom so that you can.
So, you've heard the arguments. It's going to be so much worse when you actually hear the experts. So,
And see Ms. Lewis.
Good morning, Dr. Fox.
Hi, Ms. Lewis.
So could you just please state your name for the record and tell us what your current position is?
My name is Dr. Brianna Fox. I'm a tenured full professor in the Department of Criminology at the University of South Florida. I also hold courtesy appointments at the Department of Psychology and Mental Health Law and Policy, both at USF. I'm a faculty affiliate in the Mental Health Institute at USF, and I'm also the co-founder of the USF Center for Justice Research and Policy.
Thank you. And could you, did you want to swear her in? We didn't do that.
Yes, thank you.
Thank you.
Dr. Fox, would you please raise your right hand for me? Do you swear that the testimony you'll give today will be the truth, the whole truth, and nothing but the truth under the pains and penalties of perjury?
I do.
All right, please proceed.
All right. And could you briefly describe your educational background for the court?
Yeah, well, I went to Penn State University. I dual majored in psychology and criminology. I was going to be a pre-law, but I actually changed tax. I went to the University of Florida to earn my master's, and then I earned my PhD instead of my JD from the University of Cambridge in England.
So important thing. She actually studies this. She's not like, I just went to the FBI and I took a course. She's like, I studied the shit out of this, right? And this is the defense witness that, so yeah.
Doctoral dissertation specifically evaluated the accuracy and reliability of offender profiling methods, which is obviously related to the issues before this court.
Okay, thank you. And what's your experience with the FBI?
Well, I was an honors intern. That's how I started. I went on to get a position. They asked me to join them in the behavioral science unit as a research fellow. They were actually acutely aware of the problems that they were facing with threat assessment and how inaccurate it is. So that's actually why they brought me on, was to really bring that into the modern era, improve it, use statistics and science, which they were sorely lacking. So that's how I got my start. I worked in the behavioral science unit as a research fellow. I was doing research. I was going over to the BAU. I was training people like Ms. Amon, although I didn't actually work with her specifically, and trying to get them kind of brought up to modern standards. Then I got a position as an FBI special agent. I worked in the Las Vegas division, and in between there, I worked with the Tampa field office in the field of investigations group. I actually still work with the FBI. I just did a project with them out in Sacramento.
Let me ask you just briefly, You talked about that you worked with the BSU, and I know Ms. Amon has talked about the BAU. What's the difference between those two divisions?
Yeah, the BSU was really their research arm. That was where they were really tasked with doing the data analysis, trying to develop the new, latest, and best approaches for investigative techniques. We would then go on to train both people at the National Academy. That's a prestigious group of law enforcement that come in from around the globe. We would train them, so our methods would get disseminated into their investigations around the planet. But then we would also go to BAU. We would take what we were doing, implement it. We were also trying to train them to bring them kind of up to what we were doing over in the research arm. BAU was very operational. We were the research folks.
Okay. And have you published research relevant to offender profiling and violence risk?
Yeah, that's actually the main part of my job. I have more than 50 peer-reviewed articles. I've written 5 books. I have over 3,000 citations. My work has been published in the top journals in psychology, clinical psychology.
So her credentials here are basically that she studies these risk prediction instruments and, and determines if they're valid. And she's like hugely cited. She's hugely respected. I'm like, I want to have this expert on to talk about risk assessment instruments. She sounds really interesting. So compare and contrast when you see the other person, the other expert.
Law, sociology, criminology, developmental psychology. So my goal is to actually try to create more established and evidence-based risk factors, trying to understand the development of offending. Again, this is an area that we are really lacking in, so there's plenty of opportunity for that science and data-driven research.
Okay. And do you have experience in violence risk assessment or threat assessment?
Yes, I do. I have extensive experience in both violence risk assessment and threat assessment through my academic research. Obviously, I also get federal grants. I work a lot with the U.S. National Institute of Justice. I have applied professional experience working with law enforcement agencies. This was mentioned before this, but there is a distinction between investigative efforts and then obviously applied efforts in legal setting. I would say that my experience as a FBI special agent and of course as a research fellow in the FBI's behavioral science unit, where I evaluated and then try to help improve the scientific validity of both profiling and threat indicators, is what really motivated me as a researcher, kind of trying to take a...
Okay, whoever's filming this, we do not need the inside of her nostrils. Man, they have... they're like zooming us into her acne so that we can see like which zits are about to pop and which aren't.
Old school approach and modernize it, and really trying to assess the reliability and validity of violence risk assessment, as well as these theories of behavior. That's where I won the early career award in specifically my work on.
Okay, we get it. You are the smartest person who ever lived. We're going to skip over a little bit.
To be clear, it is not a diagnostic tool. It is not a validated risk assessment tool, and it cannot be applied to individual cases. It was not created using data. It has no scientific testing or reliability. It is pure theory.
All right, let's go back to the, she's just dunking on this. So, yeah.
Model proposes just generally.
Yeah, so the Pathway to Violence model is a group-based descriptive framework. It outlines a sequence or phases of behaviors that are thought of being observed retrospectively among individuals. It's really applied almost exclusively to individuals that commit targeted acts of violence like mass shootings or terrorist attacks. To be clear, it is not a diagnostic tool. It is not a validated risk assessment tool, and it cannot be applied to individual cases. It was not created using data. It has no scientific testing or reliability. It is pure theory, and it was postulated by individuals that, frankly, I don't want this to sound mean, but they have no scientific training.
All right. And is it designed to diagnose or predict whether a specific individual will commit violence?
Again, no. It's a subjective, group-based descriptive framework. At best, it applies only to some cases. I thought the judge's explanation of it was great. You know, it applies sometimes, but in other cases, it doesn't apply. So we really have no idea how often that occurs. You know, it applies sometimes, except for when it doesn't. So it's completely disconnected from data and science.
What's the difference between a descriptive model and a predictive risk assessment?
Well, group-based descriptive models just summarize patterns or characteristics that are observed across groups of people on the average after the events have occurred. That's ones that are created using data. The ones that I'm familiar with, like when I worked in the FBI's behavioral science unit, the infamous, organized, disorganized profiles, they were created just like by thinking about.
So the, when she's saying the infamous organized, disorganized profile, she's just mentioning this, this huge issue as if we're all supposed to be familiar with it. And like, I'm familiar with it, but you can't just like drop something like that and then move on. You got to actually explain it. So
what we see sometimes in cases, and sometimes we don't. Those have also been excluded as being admissible for that same reason. That doesn't mean that you can't use them if you want to investigatively, but you can't use that later on in court to say, this person fits this profile. So predictive risk assessments, by contrast, are empirically tested.
So let's give an example of this from let's give an example of this that everyone is familiar with. You've probably heard of like the dark triad, which it turns out is bullshit. And so what the dark triad is they're like, we looked at serial killers and we found that a bunch of them had a past history of bedwetting, setting fires, and harming animals. Okay. And the problem is that they came up with that, and what that resulted in was the people got told, hey, if a kid is doing the bedwetting, setting fires, and harming animals, that they are quite possibly going to become a serial killer. And the problem is that this is actually 0% predictive. Because if you take everybody with those three traits as a kid, and you look at that, like how many of the people with those traits are going to go and, commit violence, the answer is like 0% of them become serial killers, right? Now, here's the thing. What further research has determined is that those three things are not inherently signs that you will become a serial killer. They are, however, signs that a child is being abused. A kid who has those three traits it's got a fairly good predictive element that maybe that kid is being abused. And so what that research did of like suggesting that people with those traits were going to become serial killers was it identified to like teachers and so forth a group of people that was basically like abused kids, and then set them aside for like increased scrutiny and suspicion and not receiving help for the abuse, but instead being like, tormented. So it actually, this actually ended up being a net horrible thing that we did to kids. And you'll see similar arguments done with, and I apologize, we're not even pretending that we're going to have monetization here, but you will see arguments about pornography. and they will say, hey, lots of like horrible people looked at porn. And the thing is that this has zero predictive value because lots of people look at porn and very few do the horrible things. It's not, it's not actually that the porn is causing them to do horrible things. It's just, it's a common thing in people's backgrounds. So it's, yeah, or pot being a gateway drug or various other things, right? And so you need to actually know that you've got predictive value for this, not that you, yeah. So, what do you call it? How did Karen Reed qualify for public defense? Isn't she rich? I don't think she has any access to her assets. You can also have things that are highly predictive, but only one way, right? And so what I mean by highly predictive, but only one way, is that you can get something where a common behavior might be universal among some particular group of offenders, but that doesn't mean that people, that all of the people who do that behavior are going to be offenders. And so as an example, let's look at this is especially true. Whoops, sorry, Kouri. Yeah, Kouri Richins. Yeah, sorry, my bad. I'm just, yeah. Kouri Richins rather probably doesn't have access to her money because the family's cutting her off from it as much as they can. When you're looking at extremely rare behaviors, right? Exceedingly rare behaviors. So things like spree killers or this kind of thing, right? Where you're talking about like 1 in a million people does this thing, then you can end up with problems that it becomes very difficult to get anything predictive in the future. And so if you imagine a behavior that only 5% of people do, right? Let's say only 5% of people wear newspaper hats, right? So it's an uncommon behavior with people. But you determine that like everybody who does a mass shooting wears newspaper hats. And I'm picking a ridiculous example on purpose, right? So you might say, okay, what is the predictive value of newspaper hat wearing for, somebody going out to commit some horrible crime? And the answer is basically 0, because 5% of people is 5 out of 100. And if the number of people who do the horrible crime is 1 in a million, then the false positive rate of that assessment is going to be 99.999%, and your test is useless, right? This is one of the problems here is, they're like, if you get mad at work, you might kill you might kill somebody at work. And it's like, yeah, lots of people get mad at people at work. Lots of people who get mad at people at work. It is pretty much the thing about like working with humans that you might think some of those humans that you work with suck, right? So like lots of people hate people at work. Yeah.
You want to be able to forecast individual outcomes before they occur. And just, a distinction from the group-based descriptive method, you really have no idea how often it applies or doesn't. Unless there's associated data, you really have no clue how often is it accurate. You can use the words mostly, but it's one person's opinion. There hasn't been a scientific evaluation of this to actually say, this often it applies, this often it doesn't. There's no known error rate. There's no accuracy rate. There's no reliability measure. It's just a, guess.
So that's why it's important in a legal framework that the pathway to violence is descriptive framework and not predictive.
Yeah, it's descriptive. It would be like saying that both of us are female, and females are more prone to, I'm trying to even think of an example that wouldn't, that would be kind of as like detached from the data. But we could say, well, both these women would engage in, they're both in a courtroom today, so women tend to be in courtrooms. It's like, well, just because the two people that our judges seeing today both are in a courtroom, that doesn't mean all women are in a courtroom. The example I use in my undergraduate course, every person who went to the moon eats chicken. That doesn't mean that everyone who eats chicken goes to the moon.
All right.
So there's their example. Everyone who goes to the moon eats chicken, but not all chicken eaters go to the moon. Okay, sure. So basically what they're saying is that they've got a bad science thing that is entirely based, the entire sphere of the prosecution's experts' testimony is based on a very simple mistake. And the very simple mistake here is, it's a very common one, right? All fire trucks are red. That does not mean that all red things are fire trucks. Right? It's a very common logical error. Lots of people make it. You've probably made it yourself. I'm sure I have. It's easy to make the mistake.
So does the pathway to violence, does it tell us how likely it is that someone will engage in violence?
No, that's a major flaw of it. It has no estimates for the likelihood, probability, risk. It doesn't quantify anything. There's no statistical basis behind it. There's no prospective testing, no base rate adjustment, no error rate. All the reliability measures that we would see as scientists, it has none of those.
And can it distinguish between people who commit violence and those who don't commit violence?
No, I think the major, I keep on saying this, another major problem I have with this is there are lots of people that have those grievances. I can name so many cases off the top of my head that will never go on to commit violence. And we have no idea how often people will follow this pathway and literally never commit violence. Or
Base rate problem, right? We don't know how many people have these grievances who never actually commit violence because we don't know the base rate, right? So that, I think she's really I find her a lot more compelling than the prosecution expert that's going to follow her.
they do some things and then stop and don't commit violence. There's no associated numbers with these. So people who engage in, out of the larger group and engage in similar grievances, thoughts, and behaviors and never engage in violence, we are unaware of. What the pathway to violence model is doing, they're selecting on the dependent variable. They're selecting people that commit violence and say, oh, all those people do this based on, our thoughts. It's not even based on their analysis of data.
So addressing the reliability and the 702 standards, has the pathway to violence been published in peer-reviewed journals?
No, I was actually shocked. I thought I heard somebody say that before this. I trust when I say I've researched this extensively. Book chapters and governmental white papers are not publications. Those are, they don't undergo a peer review process. I've written 5 books, so I'm aware of the process. It's not that. I've also written governmental white papers. There's no peer review process. You can write whatever you want as long as the publisher agrees to print it. You're good to go. Women's proffer, the pathway to violence model was just discussed only one time in a published paper in the Journal of Forensic Sciences. Again, I don't know how to say this without sounding like I'm mean, but
I don't know how to say this without sounding like I'm mean. I'm just going to go ahead and be accurate because she is being accurate here.
That's a predatory journal. They write to me often and ask me if they can publish whatever I want in that journal. It's not legitimate, like valid journal. So
all right, so let's talk about journals and like what the journals are out there, because a proper journal, right, when you're writing something, should be going through peer review. And what that means is that there's other other people in the field, peers, and that they are able to review it, and they're able to look for problems, and so forth. But there are journals out there that are basically pay to play. And so what they'll do is they'll reach out and they'll say, hey, we will publish your thing. You just have to pay for it. And we would love to publish. And the thing is that if you are in academia, publishing in those journals is actively, it's actively harmful to your career. But those journals will publish anything. Like if I wanted to make an ink print of my taint and get that published in a journal, I could send it off to one of those, one of those things with the cash payment, and they'll publish it. So now I'm not going to do that for various reasons, but you could. And yeah, so assuming that your paper is worth more than a taint print, you should treat it sensibly and not send it to those pay-to-play journals, because yep.
And that paper that was published in the Journal of Forensic Sciences, it wasn't even about the pathway to violence model. It was about political assassination in the United States. The pathway to violence model was only mentioned. It wasn't even a study of the pathway to violence model. So it's never been published in a peer-reviewed journal ever to date. And I think that's saying a lot.
No.
Well, just discussing reliability. Why is it important? I asked this. I've had battles on this before with experts, but why is it important that it be published in peer review journals as opposed to other journals or just being available?
Yeah, it's not so high of a standard, but that's a standard for a scientific merit and reliability. We don't give things that, stamp of approval if it's not reliable and valid. That's not the highest bar in the world. So to say it was never published in a peer-reviewed journal, I really think that's saying a lot.
Okay. Does the pathway to violence have a standardized methodology?
No, and that's actually one of the reasons why it hasn't been published, I would assume, as a journal editor. There's no operating manual. Everybody what I determine to be a grievance could be different than what Ms. Ammon thinks is a grievance or what you think is a grievance. There's no coding sheets. There's no requirement for evaluators to determine these things using the same criteria. There's no uniform objectivity in this. Everybody can look at it and say that fits, and there's subjective interpretation behind it, meaning evaluators are not constrained to apply the term the same way across different cases.
So what does this mean? It means that this is vibes. It's like, this is vibes. We don't have a consistent, means for it. We don't have anything like that. It is just, do you feel like it meets the criteria? So, yeah.
All right. So different evaluators
that's
look
pretty
at the
awesome.
exact same fact pattern and come up with opposite conclusions.
So unexpected Runkle benefits. Canadian attorney is a therapy client, and I understand what they're talking about. Thank you. That is an awesome story, and thank you for sharing. Thank you, Fender. So yeah. Yeah, this is the other thing. Pay-to-play journals equals super lawyer list. There are a few lawyer awards that are actually like awards. But for the most part, if you see a lawyer's page and it's got a bunch of awards posted, just ignore it, because you don't know if they bought those.
Conclusions, is that fair?
Yes, absolutely, because there is no standardized criteria for what these things mean. They're barely even defined because again, there's so little peer-reviewed papers even discussing it, let alone zero on it. They don't even invoke it in peer-reviewed publications. It's sort of constrained to these like side areas. So an example of this would be two evaluators could use the pathway to violence model and can reach opposite conclusions, and there's no way to determine who's correct.
Okay. So is that consistent with things that are admitted as being scientifically reliable?
No, I think it's actually the opposite. Reliability at its core means, the example again I use in my undergraduate course is if you have two people stand on two scales, you would expect that the scales say the same number. That's reliable. If we have somebody stand on two scales at my gym and at my doctor's office and there's two different results, it's literally not reliable. That's the definition of reliability. Or if you stand on the same scale every day and all of a sudden you're getting different results, it could mean that your weight has changed, but if it's 2 times in the same day, probably not. It means your scale is broken. So
all right, so there's different concepts in scientific like research design. And so there's accuracy, but there's also reliability. And so the problem with reliability is that you need the test, and there's different kinds of reliability. So there's test retest reliability, and what test retest reliability means is basically if we give the same person the same test twice, do they get the same result or a very close result? You also get inter-rater reliability issues, and inter-rater reliability is basically if you have the same test administered by 2 different raters to the same person, do they get the same result, or does it generate 2 wildly different results? And a reliable, like a test that is not reliable, is not going to be a good test. So, if you have a scale where every time you step on it, it comes up with a different number, it's not a good scale, right? It's a useless scale because it comes up with all sorts of things. And so you see this with like hair and fiber analysis where, different people, because it comes down to a subjective assessment, you don't know if they're going to come to the same answer or not. The other thing is you can also have accuracy, which matters, right? So accuracy, like let's say let's say you've got somebody who's 100 pounds exactly, and they get on a scale and the scale says that they are 50 pounds, right? Well, it's not a very accurate scale, but it might be a reliable scale because it might be that you get on the scale again and it comes out with 50, and you get it on again and it's 50. So it's a very reliable scale. It always tells me that I'm 50 pounds, but it's way off, right? That's reliable, but it's not accurate. Meanwhile, you can have something that's not, that's accurate, but it's not reliable in the sense that it might, land around the right weight, but never actually, give you the same thing twice. So all of these, she's saying these things do not pass the basic criteria of scientific assessment. And yeah.
This model is broken.
Okay. Is that connected to inter-rater reliability? I know we had discussed that, and I wasn't entirely clear myself on how that is relevant to the acceptable.
Yeah, inter-rater reliability is, again, since reliability is such a key foundational element of what is scientifically valid, interrelated reliability is basically this idea that if 2 people use the same construct, will they get the same result? And if people are having the same scale, implementing it, and get different answers, it's not reliable. And it just has a basic foundational level. So you would want the same instrument applied and to get similar results. So 2 people should be able to look at the same case and have a general agreement that this, person either meets these criteria, they would agree they're both experiencing a grievance. That's something that you would expect in regard to reliability. That's mandated for something to be considered reliable. I would actually argue that this doesn't even have the ability to determine if it's reliable, since there's been no study conducted ever on the integrated reliability on the pathway to violence model.
Does it have a known error rate?
No. And that's obviously a problem in terms of false positives. You could say, I think this person, or, this is what tends to occur.
Okay, so let's talk about whether your error rate is known versus not known, right? Let's imagine that I have developed a new test, and the new test is to detect whether or not you've got, I don't know, like some horrible disease, cancer, right? And my test, I determined that it is 98% accurate. Okay, that's pretty good, right? It means that we can determine that, we can make calculations based on that as to how many times it is, what's the likelihood that it's wrong. And so like DNA testing, we can get to some error, rate stuff. Other forms of testing, we can get to error rates, and a lot of medical tests are not 100%, right? A lot of medical tests are, they like a test that is 99% accurate is a pretty good test, but it doesn't mean that, it doesn't mean anything necessarily. And similarly, a test that's 99% accurate might still have base rate problems, right? Because if you have a condition that is 1 in a million and the test is 99% accurate, then still the vast majority of positive tests are going to be false positives, right? So you still have those issues. But if you don't actually know how likely your results are to be accurate, let's imagine I offer you, I have a test for cancer. And I'm like, I would like to sell you this cancer test. You will pay me $50 and I will give you this test. And, I will tell you what, what cancer, like if you've got cancer. And they're like, what is the accuracy rate of your test? And it's like, dunno. Something. You're probably not going to be super thrilled about this test. And, yeah, that, you're probably not going to be like, oh, right, that's absolutely worth the $50. So, yeah.
On the majority that somebody would be on this pathway to violence, you have no idea how often that happens. You have no idea how often you're wrong. You could say that.
They say, but doctors don't have reliability rates for predicting the exact moment you will have a heart attack. But that doesn't mean that it isn't a scientific prediction to say you're at high risk. They do actually have the ability to say, if you have X, Y, and Z symptoms, that this is a X% that you will have a heart attack within X many years. So they do actually do a lot better than that on those things. So, yeah.
The case, but we have no idea what percentile of the population actually fits that model, because there is no known error rate.
And why is that a problem for in terms of admissibility?
Yeah, well, without an error rate, the court cannot assess reliability. A method that you can't quantify how often it's.
Alep, this is not how they work for this test, because it's not really a test. It doesn't have any assessment. There is no aspect of, all of this comes down. This is not a properly done assessment. There is no error rate. There is no, this is the odds. This is whatever. And they don't even know if what they're doing is actually valid or not versus just bullshit. Right? So, yeah. Somebody says, interesting to hear the difference between your and EDB's analysis. I didn't watch EDB's analysis, so I don't know what she said. So, yeah.
wrong if you literally don't have that number. And this has never been studied. It has no data behind it, so you have no idea how often it's incorrect.
Okay, and has the model ever been applied prospectively to identify individuals then who later actually do go on and commit violence?
Never.
All right.
So the person in the chat who is very upset about like, it's a risk assessment thing. And they're like, no, it doesn't actually do risk assessment because you cannot actually use it that way. You cannot use it to say this person has these criteria, therefore they're going to do the things. It doesn't work like that.
Is there any scientific data showing how often a model's done by? I'm sorry, what? Oh,
I didn't say anything. My apologies.
oh okay. Is there any scientific data showing how often people identified as being on the pathway then actually never do commit violence?
No, and just without overemphasizing this, there is no reliable data on this. And I'm emphasizing it because that was why I was brought into the behavioral science unit. I was the first and only person at the FBI to do research on mass shooters and terrorists on the pathway to violence. That was literally the task I had. I was the person who did it. And this was in 2000. The first time I started on it was 2010, and then the process of getting access to data was, as you can imagine, quite difficult. I was going through all of it. I was trying to code it. I was the first person to do it. No one had done it before. There was no study ever on this. And what I've been finding, I didn't have the resources to really complete this in the way it should have been done. And it was never published. So that's why I'm also quite sure there's no publications on it. But it really was so much more complicated than what the pathway to violence model suggests. That's such an oversimplification, and it's so inapplicable in so many circumstances. And like I said, there's no known error rate. So we know it's wrong, we just don't know how wrong it is.
So what data was it developed from, the model?
The pathway to violence model, or what I was doing?
The pathway to violence model.
Oh, it's not based on any data. It's based on, I teach a forensic psychology course, and so there's a great line. I really respect the original profilers. What they did was, groundbreaking back in the 1970s, right?
So what she's basically saying is that the original FBI profilers in the 70s was really exciting, but now what we've learned is that a lot of the FBI profilers were doing was basically making shit up. And so sometimes they were successful and sometimes they were not so much. And yeah.
But obviously a lot has happened since 1977. What we've expected, in court, DNA, our standards for what we admit into court has changed a lot. But back then, 1977, when they were developing this, that was what they thought was best. And they developed it off of what they called intuition, educated guesswork, and hunches. And so I always teach my students, that was the 70s way, but we're doing this differently now. And the Pathways to Violence model was developed in that same approach. Educated guesses.
Okay, so Ms. Amon, and I suppose others who've worked on the model, believe that it can be applied after an offense has occurred. And is it scientifically valid after offenses occur to then go back and use the pathway of violence model?
No, that's like a basic logical fallacy. That was probably on your LSAT exam, you can't do that. Applying a descriptive model retrospectively to infer that the person therefore fits it is like predicting the lottery numbers after the drawing already occurred. I don't know. I don't know how to describe this another way. It just doesn't make logical sense. It is a logical fallacy to do so.
Well, in fact, an example of that fallacy is the 9/11 attacks. Is that right?
Yes, that actually, there's the pathways to radicalization. We've, toyed around with this idea. They've all been kicked around and kicked down. But that one was the pathways to radicalization profile, and it was this traits shared by attackers. They're young, male, Middle Eastern, and you could say, looking at, the 9/11 attacks, yeah, they all fit that profile. But when you apply it retrospectively, there's 55 million, right, plus people that fit that are young Middle Eastern males. Like literally it goes down from, everybody who, commits terrorist attacks fit this profile to 0.00000, like I don't even know how many digits out. 0%. It's basically 0%. It doesn't fit at all. There's no validity. There's so many people that fit that profile and never go on to commit a terrorist attack. So what's the actual value of saying this is a pathway to radicalism?
And this is in fact something that's happened over and over and over again, where like something bad happens and then so I don't know how many of you were alive and like teenager-ish when Columbine went down. Because what they ended up doing was they looked at the Columbine shooters and they said, okay, what are they into? They wear trench coats and they whatever. And then they went around and they basically decided that every kid who wore a trench coat was a potential, school shooter. And so they were like, all right, we got to hassle all of those kids. And the thing is, 0% of the kids wearing trench coats in school were going to be, but the problem, it's what's called the Texas sharpshooter fallacy, where, you shoot a bunch of holes at a barn and then you draw the circle around where the holes landed. But that doesn't mean that you've got like accuracy. It just means that you did it the wrong way. You did it backwards after the fact. And it's so many kids were harmed by the reaction to that, who never had anything that, were, anything like no plans, no anything. So yeah, it's chaos. Will there be more IRL soon? I'm not sure what you're asking. So yeah.
There's so many people that would fit that and never go on to commit the act. Cherry picking after the fact and saying, all the people fit that. Not only is that a logical fallacy, I would actually say that's, it could be a violation of people's rights, to be able to make that implication of them. Just
the thing is that it's not just that you have to study them retroactively, but you also have to look at the predictive effect, right? So, you're saying, okay, we're going to go after trench coat kids because, because of this. Well, you can't just go and say, okay, we're going to look at this guy had trench coats and then dial it back. You have to look at how many people of the pool of people who wear trench coats go on to do something like this. And you would see that the predictive value is nothing, right? The predictive value is very, very low. And I mean, to give you an example of this, another example, most essays are done by men. And I say most, it's not all, but most are done by men. But knowing only that somebody is a man tells you almost nothing about their likelihood of committing an essay, because it doesn't work that way. There's so many men out there not committing essays that the predictive value of only that is just about nothing. Now, that doesn't, the prediction only works one way. If you heard somebody committed an essay, you can predict that they're very likely to be male. But if you hear that somebody is male and that's all you know, it tells you very little about whether or not they're going to commit an essay, right? So the prediction has to go in the correct direction. And if it doesn't go in the correct direction, it's probably useless garbage.
Without even having a 1% accuracy rate.
So how does that relate to the pathway to violence model?
The pathway to violence suffers the same fatal flaw by implying these group level descriptives. You're first of all applying it, and we have no idea. It could apply to 1% of people that have a grievance. They, go to a workplace nowadays, right? So many people have grievances. So many people are upset. They're feeling stressed by the economy, by their, situation. They even may say, "I'm so stressed, I'm mad." They will never go on to commit violence. This is an extremely rare base rate event. And low base rate events have very high risk of false positives. And when you are now going to take that and enter it in as an expert opinion, obviously, just me as a scientist, as somebody who supports the research in this area, and of course, like as an American taxpayer, I feel very concerned by that.
So let me ask you, you heard the discussion before you testified about if Ms. Amon were to testify in rebuttal, that why someone who is a mother or someone who is in the position of Ms. Richins might commit this offense because of being on this pathway to violence. In your expert opinion, is that helpful to a jury, and why is that problematic?
Yeah, I actually think that the risks are so far beyond the benefits. I mean, there's so many people that experience grievances, anger, even violent ideations. There are a lot of studies on that. So there's plenty of research that can be discussed to talk about the base rate of those. They're high, but then when you look at the predictive ability, how often do they go on to predict violence? Extremely low. The reason is because, if we were that good at predicting violence, I mean, think about the problems we have when we're talking about parole. We're talking about, risk assessment.
And this is the thing, is we actually are pretty dog shit at predicting violence. Like, even amongst populations that we think should be fairly easy to predict, like even when you're talking about people, and I mean, it's not... Casually, people are bad at predicting violence. So, like, if I asked you who was more likely to go on to commit a murder, somebody who's been convicted of breaking and entering, or somebody who's been convicted of murder. And I'm guessing most of you would say, hey, you know what? The person who committed a murder is probably more likely to commit a murder in future after release from jail. Nope, other way around. Now, part of this is the fact that somebody who's been convicted of murder is probably getting released when they're like 60, and 60-year-olds don't commit a whole lot of murders, whereas somebody who's been convicted of a break and enter is probably getting released still in their 20s, which is prime murdering age, right? And so, there are other factors here, but because life is so complicated, there is, it can be very difficult. So, and we end up with these questions, like this person who committed a horrible crime, what are the chances that if they're released, they will commit another horrible crime? And, it's like, well, we don't know, right? We just don't know, we just don't know for that. And what is it? So any test that promises that it can predict crime, we need to be skeptical of, because they're most of a thing. Lol, prime murdering age, what on earth? Most people who commit a murder are going to do so between the ages of about 14 to 40, right? And after that, the murder rate drops to basically none. So, yeah.
We're looking at releasing people. We're doing, my big NIJ grant was specifically to do risk assessment to try to identify people who are low, medium, and high risk. This is such a big area because we are so bad at it, even with huge amounts of data, huge amounts of research behind us. There's no way that something like this is able to be better than all of the research and data that we have based on hunches. Our data suggests that things like grievances, feeling anger, violent ideation, they have such a low predictive ability to actually accurately predict violent behavior, because violence is a low base rate phenomenon. Lots of people have these types of feelings. Very few ever go on to commit violence. Even if you fit all of them, you literally have a low probability of actually committing violence.
The number of people who have absolutely hated somebody at work and not killed them is huge, right? A huge number of people hate somebody at their workplace and go about their day not murdering them. I have quit jobs because I could not stand a coworker, and that coworker is, to the best of my knowledge, that former coworker is still alive. I don't know, because I've never had any interest in like checking up on the person or anything like that, but I have left jobs because I was like, fuck this person. So, every workplace has the person who makes popcorn and salmon in the microwave. Every workplace has the guy who like clips his toenails in the elevator or whatever the heck else, right? So but we're not murdering those people, right? It's just not what most people do. And so, sure, if you go and you look at somebody who does murder somebody, you might find that, sure, they got real angry at their coworker ahead of time. But that doesn't mean that everybody who gets real angry at a coworker is going to murder them. It just means it might be a prerequisite instead of a sufficient condition.
I could actually, look that up in a couple of minutes and tell you what the base rate is, but because this pathway to violence model has never been evaluated, anyone who would say, here's what I think, they're just guessing on how often someone would actually go on to commit violence.
Let me ask you, tell me if I'm wrong. When I was looking at the pathway to violence, it appeared that the purpose of it was to try and help identify mass shooters, school shooters. Why has this been put together? For what purpose, if it doesn't actually ever predict who will go forward to commit a violent act?
I'm telling you guys, if we were able to predict with any level of accuracy who was going to become a school shooter or a mass shooter, we would have a much better situation in our world right now. Again, even with accurate data, like we're collecting.
I'll tell you how well we do at predicting any of this stuff, which is zero. We are totally unable to predict mass shooters. And any attempt we make to predict mass shooters makes things worse, because we don't actually predict the shooters. We just hassle a bunch of innocent people. That's all we do, right? So
looking at this, putting very sophisticated predictive models together, we are so unable to predict violence, school violence, these targeted violence offenses, and domestic violence is even harder to predict. As our judge mentioned earlier, the vast majority of them are emotional. They're not these, long premeditated, thought out things. So the emotional dynamic factors actually have a much higher predictive validity than, any type of, long-term grievance, at least based on research. If we were able to do this, I would feel much better about my young son, going to school soon. I'm terrified because we are so bad at it. Even from a magnet, huge amounts of money being spent on this type of research, we are still unable to do it with any type of reasonable accuracy, because finding that needle in a haystack, someone who meets all of these criteria but is actually going to commit violence, is so hard to do.
Let me ask you, just for sake of argument, if we were to assume that the pathway for violence had some reliability in the area of mass shooting and school shooting, was it meant to be applied in this sort of case?
Oh, no. And that's actually, again, something I talk about in my undergraduate courses. We have this problem, it's like mission creep. We think, because it applies here, it can apply over here. And that's absolutely not the case. A domestic violence type of scenario, poisoning, or they're so fundamentally different in the way those two things are committed, played out. Applying something that is, even without data, created for the purposes of these targeted attacks that do engage in more radicalization behaviors. You applying that to something that's statistically more emotionally driven, that would be very inappropriate.
All right. So just to wrap up, in your expert opinion, should the pathway to violence be admitted as scientifically reliable evidence that a jury can rely on?
No, absolutely not. If we're basing this on reliability, if we're basing it on, how using it to know that this is scientifically valid, absolutely not. The logical fallacies that are endemic to this, the huge amounts of unknowns, like how often it's wrong, which would be far more wrong than right. It's akin to
We
like
didn't
the
hit
Barnum
that
effect
goal.
at circuses, or like psychics. That would be the closest, I would say, in terms of how accurate and valid and applicable this would be to an individual case.
I have nothing further.
Ms. Shervnak, do you have any questions for Ms. Fox?
I do.
Ms. Fox, may I ask you just a couple of basic questions?
Pathway to Violence sounds like a garage band name. I would totally name a band that. So yeah, the prosecution has no questions. I set a Pizza Bones goal. We didn't hit it, so I set a new Pizza Bones goal.
Surely.
You went through the FBI Academy at Quantico.
Yes, I did.
Were the pathways to violence taught as part of that curriculum?
No, it wasn't.
Did you have exposure to this during your career in the FBI?
You're not wrong.
No, I wasn't. There are these, similar models, like, I think they call it like pathways to radicalization.
I may
and
stop
just
doing the
learned
goals,
about that,
'cause,
and again, like while I was in the
but I don't know if
that was one of
anybody
the
will
things that I
super
was
chat if
brought
I
on
don't.
to try to revamp and improve.
Okay, thank you. Ms. Lewis, anything further?
No, you're
Okay. Ms. Shervnak, anything for Dr. Fox? Okay. Thank you, Dr. Fox. You're welcome to stay connected, but you're also welcome to turn off your video and audio.
The thing is, there are much better tests out there. There are much more useful tests than this one, and this one is not so good. And it's gonna be even more clear that it's not so good when the prosecution calls their expert to talk about how good they are.
Thank you.
Ms. Lewis, do you want to ask any questions of Ms. Amon?
Are you not going to put Ms. Amon? Is the state going to put Ms. Amon on, or only if I have questions? I guess would be
Ms. Shervnak, are you relying on her proffer, or do you want to elicit some testimony from her?
I'll elicit some testimony from her.
Okay. Ms. Amon, do you mind turning on your video and audio?
Yeah, this
the
is Kouri
expert,
Richins
please.
before trial.
Do you swear that the testimony you give today will be the truth, the whole truth, and nothing but the truth under the pains and penalties of perjury?
I do.
All right.
Good morning, Ms. Amon.
Good morning.
Your Honor, before I begin with her testimony, Ms. Amon's CV lays out her qualifications. The state's position is that she possesses the requisite knowledge, training, experience, education to satisfy 702A. If the court sees it differently, I'm happy to ask her some of those questions, but I prefer to focus my questions directly.
So the prosecutor's like, remember how we went for like 45 minutes with the defense's expert talking about how awesome she is? Can we skip that? And the judge is like, yes, we can.
Elsewhere, if that
I
makes sense.
agree that her CV reflects that she has sufficient education, training, and experience to qualify under 702A as an expert in her field.
Thank you, Your Honor. So, Ms. Amon, I don't think we need to go through all of the steps of the pathway to violence. I think The court has the generalized view of it, but what I would like to ask you are a few questions about how this model was developed, and we'll start there.
Sure. So in terms of how the model was developed, you'd have to, I guess, go back. The scientific research leading up to where we are now started about 100 years ago, give or take, when researchers began studying aggression in mammals. Specifically, cats were the sort of the origin story of this line of research. And
Oh my fucking God. I was already like, man, what? You're talking about human behavior, and you start off with, we're going to understand why humans commit homicides by looking at cats. And I'm like, all right, I like cats. Cats are great. But cats are not a good model for this. And Chelsea Rama, I hit enter too soon, but TLDR, I feel like implementing goals has led to fewer super chats, global issues aside. Thanks for covering the Uvalde trial. I feel like you might be right, and I might try not doing super chats for a while, but, or not doing goals for a while. I don't know. I feel like most of the, I don't know. I feel like I'm struggling a bit. So, yeah.
researchers noticed two distinct patterns of aggression in cats, depending on the circumstances. In some studies, cats were presented with a threatening stimulus, a very threatening stimulus. And in those cases, they demonstrated intense autonomic arousal. So arched back, fluffed tail, hair along the midline, standing on end, that's called piloerection, pinned back ears, they vocalized, such as hissing and growling, fangs out, claws bared, the whole show. You can sort of think of it as that classic Halloween decoration of the scaredy cat with the arched back and all that. And they very quickly lashed out with an emotionally charged and relatively uncontrolled attack with paws and claws. And that was labeled affective violence. Affective for the psychological term affect, meaning sort of the state of thinking or emoting or feeling emotions. And then in other studies, the cats were presented with prey, like a mouse. And that was a totally different story. The cats were low to the ground, completely silent.
So, Kouri Richins' expression right here is like my expression. She's like, I might go to jail because somebody is trying to say people are cats. Like, if you're wondering about the junk science, now we're into junk science here. Yeah.
That was a totally different story. The cats were low to the ground, completely silent. Ears, instead of pinned back, they were open to localize sound, and the cats would inch forward.
Do you think Kouri Richins is planning to eat him? Do you think Kouri Richins is planning to eat Eric Richins? Like, is that the plan? Because if not, then the predatory behavior of cats is probably not going to have any connection to this at all. Like, and yeah, watch Kouri Richins.
They were open to localize sound, and the cats would inch forward, and they appeared to be planning and carrying out an attack at the moment of their choosing, typically with a bite to the neck or head, a very efficient biting attack that ended the fight really before it began. And over the next several decades, that line of research expanded to other mammals, including humans. And what they discovered was that not only do these behavioral patterns hold true in humans, but they're also biologically distinct from one another. And the understanding came now that affective violence, so that reactive attack, is triggered by lower brain structures in the limbic system, triggering an intense autonomic arousal, as I've discussed, usually accompanied by intense fear or anger and a cascade of hormones, all culminating in a sudden physical defense against imminent threat, which could be real or perceived. It could be an internalized threat. And the evolutionary basis for that in humans is survival. So if you were an early human out on the savannah, There was really no time.
Okay, so this is when we start getting into evolutionary psychology. And here's the problem. We have no ability to actually test any of the bullshit she's saying. She's like, when you were an early human out on the savannah, you had to react fast. Maybe, or maybe early humans on the savannah survived better if they thought about things before reacting. We don't fucking know because we have no time machine. But what this is a lot of people who get into evolutionary psychology fall into this pattern where they basically make up stories about how evolution worked to generate and to support like some observed or hypothesized belief. And it's like, we don't fucking know. We don't know what 8 humans and how their reactions mattered to it. Like, we don't know. She's making this shit up. This is made up shit. And it might not be that she's making it up, but it's this discipline of science has made it up. We don't freaking know. You know,
Time to ponder whether that movement in the bush was caused by the wind or a predator. The early humans who acted quickly were the ones who survived.
How many predators eat humans? Because I'm just going to tell you, there's not a lot of predators that eat humans now. And I'm guessing that there weren't a lot of predators that ate humans back in the early days either. There's really like a limited number of animals that eat humans. Most animals avoid the fuck out of humans. And so this notion that we have this entire evolutionary sphere to like, I'm like, most things don't eat us. Most things run away from us. I don't, like, come on. We don't know this. This is just, yeah.
In terms of predatory violence, we now understand that to be characterized by a lack of autonomic arousal or emotional experience and no perception of a threat. And that lack of stimulation allows for higher cortical activity in the brain to choreograph an attack that meets the attacker's goals, whatever those goals may be. And the evolutionary basis for that in humans is hunting for food. So early humans on the savannah who hunted with minimal autonomic arousal, no anger or fear, were better able to engage higher brain functions to plan and prepare in advance, and therefore were likely to return with food for their offspring. Those who could not or did.
You don't fucking know this. This is a, you know, what is the basis for this story you're telling us? Oh, well, we made it up. Cool. Great.
Did not do that, were less likely to survive and pass on their genes. And we know that humans, like none of us would be here right now if our ancestors didn't have the capacity for both of those types of violence. So fast forward to now, there have been studies on neurochemicals and hormones, neuroanatomical brain scans with PET and MRI to look at the differences between these two modes of violence, and all of them support the bimodal nature of violence. So that research evolved more or less concurrently with behavioral studies that were going on in the 80s and 90s on attacks against celebrities, judges, governmental figures, and some others, all of which led to a very clear conclusion that intended violence is a process composed of discrete, sequential, and recognizable behaviors. And the pathway to violence model came into being at the conclusion of that time frame based on the biological data and the behavioral observation data from all of those studies, many studies. So that's kind of a 10,000-foot view of the science in terms of how we got to where we are now.
So how is the pathway to violence used in the behavioral analysis community?
We use it not to predict, but to prevent. And that's a very clear distinction that needs to be made. Prediction is not possible. We don't talk about predicting human behavior. We talk about preventing it. I would liken it to if, let's say, I'm your cardiologist and you came to me and you were very overweight, sedentary, hypertensive, you had high serum cholesterol, you had bacon for every meal, and you were super stressed out. As your cardiologist, I couldn't tell you that you're going to have a heart attack next Tuesday morning at 9:24 a.m. But what I can tell you is that you're at heightened risk for cardiac event. And we need to manage your condition with lifestyle changes and probably some medication to lower that risk. That's how we work in behavioral threat assessment. And the pathway is part of that. It's only applied in cases where where someone has already presented themselves to authorities, to whoever, as raising concerns for violence. So the person is doing something that has brought concerns of violence to the table. Whoever's bringing us the case, maybe it's a school district, maybe it's a workplace, isn't sure what to do. We would begin to look at the behaviors the person is demonstrating, and are being on the lookout for possible pathway behaviors is one of the things that we would do. It's actually considered one of one of 8 proximal warning behaviors that we would look at to decide if this person needs a deeper look. So it's a tool. It's one of many tools we use. It's certainly been subject of many studies in terms of whether or not it's valid for measuring what we want to measure. That is behaviors that raise for us concern about whether or not violence might be on the horizon.
It's been the target of many studies. What did those studies show? Yeah, that's okay. All right. So the pathways to violence are basically, there isn't any like actual testing elements to it. It's things like, are people expressing grievances, and, you know, do people have thoughts or fantasies considering use of violence to address those? Yeah, that's, lots of people have like fantasies of violence, but that doesn't mean that fantasies of violence ever go anywhere, right? So,
And is the pathway to violence utilized, or could it be utilized in instances of targeted violence that only include one individual as the target?
Oh, certainly. Targeted violence is targeted violence. They all share behavioral commonalities, particularly where the pathway is concerned. If you understand the nature of the items on the pathway, then you also understand that the majority of them are steps that most targeted violence offenders would pass through. Whether you're planning to kill 100 people or one person, you still have to make the decision to do it. You still have to engage in some planning, some preparation, even if it's very, very simple.
the thing is if you had a consistent criteria for this pathways to violence, which you don't, that doesn't exist. But if you had a consistent criteria and you could get people assessed for this ahead of time, it has basically no predictive value for telling you that somebody who is a high, like assessed high here, is likely to commit violence. It works the other way around, but it doesn't work predictively.
Some people require a lot of planning and preparation. Some people require very little to get to a state of readiness. But it doesn't really matter what the size of the targeting is. That's not relevant.
Oh, so some need lots of prep, some need very little. Okay. So it's a range from everywhere from lots of preparation to almost no preparation. Cool. Your test is going to be fantastic when the range is the entire fucking planet. Yeah.
What's relevant is that certain behaviors must occur in most cases in order to get someone to a state of readiness to engage in planned violence. I'm not talking about unplanned violence or affective violence. That's not really relevant here. But most people will have to pass through some of those stages, if not all.
Is the pathway to violence model generally accepted in the behavioral analysis or behavioral science community?
Absolutely. It's completely foundational to what we do. I know of no learned and credible threat assessment professionals who don't believe in the pathway. It's at the foundation of what we do. It's included in virtually every aspect of what we consider the body of knowledge in behavioral threat assessment, which I used to administer. I'm a former chair of this national certification program in this discipline, and the pathway is very foundational.
And is that something that you would describe as currently used, or is this a past, a model that was used in the past, or is it a currently used model?
Currently used. Up until about 2012 or so, it was kind of it was the name of the game. It was the pathway. And then right around 2012, we had the realization that it's but one of 8 proximal warning behaviors, proximal meaning close in time to a potential act of violence. And so now we tend to look at pathway as one of those 8. So in terms of more recent studies, in terms of its validation, it's the proximal warning behaviors that we look at. We don't usually use the word pathway necessarily on its own, but it is a discrete behavior as part of the 8 proximal warning behaviors. But it's absolutely used now. It's very, very important to what we do.
And now, if you could explain the retrospective analysis and why prospective analysis is not feasible.
Sure. All the studies on pathway and proximal warning behaviors are retrospective. And in fact, someone asked me at a conference the other day, where are we on prospective research? And my answer was nowhere. We can't do it. So retrospective analysis is looking backward at cases with a known result, so violence. So let's say I want to look at a single person homicide in a workplace. I would look backwards at the completed event, knowing that it had the result that I'm interested in, violence. And then I would look for what patterns of behavior can I identify that did occur leading up to the violent event, and then code those. And so I would know that those occurred. So a retrospective study would have a sample of cases and then look backward in time and code the behaviors that we know to have occurred. And that helps us to understand what are the common.
Here's the problem. Retrospective studies always have an issue with, do they work prospectively? Retrospectively, if you look at people who have committed genocide, you will find that 100% of them drank water. And so you might, if you're sitting there and you're only looking at the people who commit genocide, go, wow, what an interesting thing we've discovered. They all drink this water stuff. And then you realize, oh, wait, that doesn't mean shit. Because if you do it as a prospective study and you're like, how many people who drink water are going to whatever? The answer is none. Chrissy, I'm not doing it, and please don't pitch other channels here. So I'm like, this is not good. This, as I was listening to her defense, I was like, I thought the defense expert was probably just being unfair to the prosecution expert. I was like, it can't be that bad. She's over hammering it, whatever. And then the defense expert gets up and confirms all of this shit. And I'm like, y'all, this is so bad.
Analogies. You can't. Dr. Fox is absolutely correct that those studies can't be used for prediction. They're not predictive validity studies, but what they do is validate the measure as measuring what we intended to measure. Prospective is you would need a prospective study to truly call something predictive, but to do a prospective study in violence would be to have a case of concern, and then look for what you believe to be pathway behaviors. And once you've identified them, it would require you to sit back and do nothing and allow violence to unfold and then code your data, which is horrible to even think about. None of us would ever do that. So we use retrospective analysis, and it's widely acceptable.
You can, however, do retrospective prospective. And what I mean by that is that you can go back and look at whether or not the behavior actually predicts anything, even in the past, right? And the way to do that is that you go and you say, okay, well, we have found that so many of these serial killers had the thing of bedwetting, animal abuse, and fire setting. Okay. But then you can go back and say, all right, let's figure out how many people alive right now had those behaviors as a kid, right? And you'd be like, oh, it's thousands and thousands and thousands and thousands and thousands. And how many of those people went on to commit, serial killings? And it's like very few. So, there's no ethical issue with that because you're not like waiting for somebody to engage in serial killing, but you can still test this and you can still see if it works prospectively. And
The behavioral sciences
angry
research strategy.
Thank you. Just a moment. Those are my questions for you at the moment. Thank you, Ms. Amen.
And now we get the cross.
Just a moment. Good morning, Ms. Amon.
Good morning.
So, Ms. Chervenak asked you how the model was developed, and you told us about cat research, but I didn't hear an answer as to how the model was actually developed.
Sure. So in the 80s or 90s, a number of studies were conducted on attacks against public figures, political figures, judges, other people. And in those studies, it became quite clear that the offenders were typically engaging in a sequential and recognizable cascade of behaviors leading to the violent attack. And so that became...
But is it recognizable ahead of time or only after the fact, right? Because you can have these things that are recognizable after the fact, but like everything is predictable after the fact, right? How did you know that would happen? Well, because I already knew it would happen. And I saw that I missed a chat that I got to address, and here we go. Whiskey Pig says, "Hi, Ian. My cat is not enjoying this person's testimony one bit." This one is kind of pointing the finger at the cats. It's like, cat's bad. All right. Let's watch the cross here.
The pathway to violence. The data collected from those studies showed that 6 particular discrete stages were happening in virtually every case that was studied back at that time. And so that became the pathway to violence. Does that answer your question?
A little bit. So, but the pathway to violence talks about... Well, strike that. Let me rephrase. So you used the analogy of a cardiologist. You said this isn't predictive, it's preventive.
Right.
Right?
Right.
So this only applies after an event has happened?
No, not at all. That's how we have studied it. How we use it is in advance. So let's say, for example, you are a school principal, and a child in your school has risen to your attention as raising concerns for violence for whatever reason. Maybe he's got a hit list, maybe he's stalking his girlfriend. So I would look at that if I were consulting with you, and I would ask for everything you know about the situation and the child, and I would look for evidence of these 8 proximal warning behaviors primarily that we know to be well correlated with subsequent violence, including the pathway. And if I saw evidence of any of those, then I would advocate for active management of the case to try to reduce the violence risk. The general rule is that once you observe 1 or more of the proximal warning behaviors, then some sort of active management is necessary to prevent violence. So we're managing behaviors of concern in the present to prevent violence in the future. We don't.
Except they don't actually know if these behaviors lead to violence in any coherent pattern. This is basically the trench coat shit happening again. And yeah, I'm just like, oh my God. Oh my God. She's like, we need to know what kind of trench coats people wear that, that then we should hassle them. And it's like, how often does that lead to violence? Dunno. I see a request here. Thanks for covering this. Need a pup swoop. I think we can do a pup swoop. Where's a good pup swoop? Here we go. All right. Yeah.
Know that the child is ever going to be violent, but we're not waiting around to find out. We're going to take active steps to try to prevent and manage.
And you have no idea if absent those active steps, would that child ever have committed violence, true?
No idea is a bit strong, but do we know? No, we don't know. That's correct. It's someone.
So we are taking pre-crime steps because we don't actually know if they're going to be violent, but we're going to treat them like they're going to be violent because we think they might become violent. And there's no way for us to check our homework on this as to whether we were right to fuck with this person's life. Yeah, this is bad.
Can certainly ride the pathway all the way up to one of the upper steps and then never do a thing. That's entirely possible.
All right, so you talked about that it has been subject to many studies. Could you tell me what studies this has been subject to?
Sure. Yeah, I was a little bit surprised to hear Dr. Fox say that it has been subject to no studies. The most recent study that was specifically on the pathway and only pathway came out in 2024 in the Journal of Threat Assessment and Management. And they had a very high, actually high inter-rater reliability score in that study. I would say the majority of studies in the last decade are more on proximal warning behaviors as the label that you would have to search by rather than pathway. They're on, almost more than I can count. Public figures, mass attackers, intimate partner homicide offenders, other sorts of family offenders like paternal filicide, maternal filicide, that kind of thing. Workplace, classroom. The journals are really littered with studies looking at proximal warning behaviors.
Are there any peer-reviewed studies that you can point to that adopt this?
All peer-reviewed studies, all of them.
Are there any peer-reviewed studies? All of them. All of them. Okay. This is not good experting right now.
What are they?
Well, I supplied a list to Ms. Shebernak when they first contacted me, but the most recent one that I mentioned in 2024 is called "Are All Pathway Behaviors Observable? A Quantitative Analysis of the Pathway to Intended Violence Model." And that came out in the Journal of Threat Assessment and Management.
So the same one you just told me about?
Yes.
Okay.
It's like, so which studies? The same one you just told me about. Okay, cool. So we're up to one.
All right, so it's not a predictive model, it's a preventive model. It's not capable, you can't generate any numerical score, correct?
No.
Using this. And it's not designed to determine if a specific individual is going to commit violence, correct?
No, I agree with Dr. Fox's description that it's a descriptive model. It describes behaviors that have been observed in studies. I would say its operational use is not in prediction, but in prevention, which I think is really a key difference in terms of how we use it in the field.
So it could be useful if someone came to the FBI and said they're thinking about a mass shooting.
I'm not sure I take your meaning.
Well, if it's not useful in predicting violence, and it's useful, as you said in your cardiology example, if someone comes in and says, hey, I'm having these symptoms, then, you can help prevent it. So how is this at all useful in the real world? Because people don't come into the FBI and say, I'm having these symptoms, and you can say, well, you are on the pathway to violence. Let me help you.
So here's the thing, why these experts pertain to this case. What the prosecution is hoping to be able to use this expert to do is to basically say Kouri Richins was on this pathway to violence, and we know that this is the pathway to murder. And here are all of the steps that she was doing that are murdery. Therefore, she murdered Mr. Richins. That's what they want this expert to be able to do. And so they basically want her to say, she seems like the kind of person who would murder Mr. Richins. Basically, they want to backdoor character evidence in order to point to Kouri Richins. And quite practically, this, the defense is like, no. Now, the defense does a really good job here. They don't win on everything, but they pack the prosecution into such a corner that they've basically won this issue. The defense wins the day on this point. I think it's not a complete defense win, but it's a nearly complete defense win.
That doesn't happen, correct?
Yeah, that's never happened as far as I know. But how it is used is if I'm looking at a case where someone has already risen to the attention of whoever is observing as someone being of concern for violence, maybe they've been making threats, maybe they've been menacing people, maybe they have a hit list. I mean, whatever. That can look a million different ways. Then I look at the entirety of the case, as many facts as can be gathered, and then I begin looking for signs of proximal warning behaviors to decide if we're in sort of an imminent countdown potentially to an act of violence, and that's where the pathway to violence becomes quite useful. If I observe someone on the pathway, particularly in late-stage pathway markers, then I might develop, depending on the context, I'd have a lot of questions, but I might be...
She's like, I can predict that somebody might commit a murder if they have a hit list. Okay, cool, neat.
become very concerned that we're close to a potential act of violence.
Has this ever actually happened in the real world?
Yeah. The prosecution gets backed into only using this as a rebuttal expert if the defense tries to argue that she'd never do this. But that's not their position. The prosecution wanted to be able to bring this witness on as a rebuttal witness, but they were gonna tender this witness, right? They wanted to bring this witness in for, here are the patterns, right? But that's what the defense successfully limits the prosecution to doing, right? So that's what's the prosecution's left with at the end, but it's the prosecution's losing position. It's what they get left with after they lose on this.
Where you have stopped violence based on something that was brought to your attention?
Well,
how can you say that has happened?
We can't. That's what I mean by there's no prediction. I can't. So when we see pathway behaviors or other proximal warning behaviors,
So it's a predictive test for intervening that they can never tell if actually worked right. And so it's like, well, when somebody does these things, we think they're a witch, so we burn them. Okay. How many of those people were actually witches? We don't know because we burned them. Okay. That's concerning, right? Yeah. They said that they wanted the witness as a rebuttal witness, but they wanted the witness as a much broader rebuttal witness than where they get backed into. They get backed into, you can only use them for rebutting a very specific assertion. And I mean, there's certain rebuttal witnesses that are going to get brought in. So yeah, they were planning on bringing her in.
That's our job, is to intervene. So once we've intervened and there's no violence, how can we ever say that there would have been violence but for intervention? You can't. You can't prove it never happened.
All right. It's fair to say that two evaluators could look at an individual and reach completely different conclusions, whether someone's on the pathway to violence or not, right?
Not well-trained evaluators.
So your testimony is that
Not well-trained evaluators. So not true, Scotsman.
people always come to the same conclusion if they're trained in this.
No.
Okay.
Yes,
So
Shaby
people
is
can
here.
come-
Shaby's here. I've seen her in the chat. It's just that they YouTube screwed up everybody's username. So I hate that.
to different conclusions, even if they're all both well-trained people.
I think if they're well-trained, they should not come to different conclusions on something as fundamental as the pathway. You can come to different conclusions about how close someone is to violence.
But it's subjective, right? It's not based on scientific data.
Well, it is based on scientific data. All those studies that I referenced in the 80s and 90s that helped Brian Foskule, Randy Vorum, and Robert Fine arrive at the pathway to violence. That's data.
The journal we talked about that it was published in.
No, that's a different journal. There are dozens of studies, but what we're talking about, the study I referred you to was in 2024.
If you're going to be an expert and you're going to talk about the dozens of studies, you need to have notes where you can actually bring up the dozens of studies, because that's really what you got to do. Also, I see we've got nearly 1,000 people watching on X. I'm going to invite you, if you're willing, come on down, watch it on YouTube, because YouTube is overall better for like my value than Twitter. But watch it wherever you'd like. But yeah.
Just because it's the most recent one, specifically on the pathway and only the pathway, but the journals I'm talking about we're talking like 80s and 90s.
There's no way that the model can tell us how often it produces false positives, right?
Correct.
And you can't tell us the model's error rate. True?
Correct.
And this is the thing, is that the false positive rate is the most important thing, right? Let's say we had a test that was only 10% accurate for identifying when somebody has committed a murder, right? 10% accurate for identifying when somebody's committing a murder. But that it's got a 0% false positive rate. That's still a pretty useful test, because if it comes up positive and the false positive rate is 0, well then, you know, somebody who tested positive did the murder, right? But, you know, let's imagine the other, example. Let's say we've got a test that identifies a true, correct murderer 100% of the time, right? 100% of the time. But it's got a false positive rate of 75%. Well, then this test is garbage. It is completely useless, should never be used on court at all, right? So, yep. The false, you need to know the false positive rate. You need to know it in order to determine if a test should ever go into court. So yeah. We talked about the Uvalde thing. It was the first 30 minutes. So yeah.
You can't quantify the likelihood that an individual identified as being on the pathway will not commit violence.
I can't quantify whether they will or will not. It doesn't work that way.
Yet you believe you could apply this framework in this case?
I don't know anything about this case, actually.
Well, you know what the defendant's charged with.
I believe it's a homicide, but I don't know any facts and circumstances or if there are other charges.
Okay. Are you familiar with the case United States versus Wells?
I am not.
Isn't Agent Malloy a colleague of yours who helped write the Pathway to Violence?
Agent Malloy? Oh, Dr. Reed Malloy?
Yes.
He's not an agent, and he didn't write the Pathway to Violence, nor did I.
So you're not aware, you gave the example of workplace shooting.
Okay.
So you're not aware that that is the exact case that was rejected as the science being unreliable in the United States versus Wells. You're not aware of that.
I'm sorry, I have no idea what you're talking about.
All right. Have you testified in a homicide trial about the Pathway to Violence previously?
I have not.
Have you
Nope.
testified as an expert previously?
I have not.
Can you give me any examples where the pathway to violence was used in the courtroom at a homicide trial after the fact?
I don't know.
Okay, I have nothing further.
Ms. Shermanek, anything further?
No.
Okay. Ms. Ammon, thank you. You're welcome to turn off your video and your camera. Why don't we take a...
Kouri Richins is like, can you believe this is the evidence that they want to bring against me? Now, the thing is, they don't need to bring in dog shit witnesses like this. They have good evidence. Use the good evidence. Don't bring in the dog shit. Like, All right, we're gonna skip ahead to post break, and we're gonna watch sort of the result.
Whatever kind of agent he was in drug cases, he always saw this same profile of drug couriers.
I think he said most, didn't he? Isn't that the distinction?
It might have been, I don't know if it was all or most. It was most all.
Key part of the case is that he said most, and that's how Justice Thomas said, well, that's not impermissible under 704B because it acknowledges that there are some outside of most who don't know.
Either way, it's different because he was an experienced witness, not an expert witness. And in this case, Ms. Ammon is not an experienced witness. She didn't write this. She hasn't done, she can't get up there and say what the detective said in that case because for a number of reasons. Other people did the studies.
May I cut to the chase a little bit here to see if we see it the same way? I agree with the defense that under cases like United States versus Wells, the expert testimony that Ms. Ammon offers cannot be used in the state's case in chief and cannot be used in any part of the case as substantive evidence of defendant's guilt. Here, though, the issue, based on briefing, is more nuanced. It seems to me that the state could use Ms. Ammon's expert testimony in its rebuttal case and only to rebut a general categorical assertion by the defendant in her defense case that this is simply not how it works. This is not credible that someone would engage in a weeks-long campaign to kill someone in the absence of an imminent threat to their life or some kind of emotional or extreme impetus. If there's that kind of categorical, generalized argument made by the defense, then I think this testimony from Ms. Ammon, which is based upon a retrospective study of killings that actually occurred, saying in the retrospective study of killings that actually occurred, people did plan them over a varying level of time, and there were steps they took along the way. As long as the prosecution did not turn the corner in closing argument to say, well, we've showed you elements of plan and preparation on behalf of Ms. Richins. You heard Ms. Ammon, so that shows it's more likely than not that Ms. Richins killed her husband. They can't do that in closing. That would be using an inappropriate profile-like argument. But to rebut a categorical, generalized statement from the defense that this is simply not the way homicide works, I think that would be helpful to the trier of fact under 702A. Tell me why not.
Well, first of all, this would be the first time that it's ever used that way. You heard Ms. Ammon, this has never been used.
Well, that may be because it'd be the first time that a defense has ever made that kind of argument, but I'm not sure we're going to have to cross that bridge here.
Well, we may not, but I think it's never been used because it's not reliable. The study wasn't made even though to pick out individuals who commit violence. It was developed, she said, the only time...
But they're not using it predictive in my hypothetical. They're only using it to rebut a generalized statement of murders don't get planned like this.
Well, it can't be used predictive. I think that was pretty clear.
Right,
It's
I'm agreeing
not.
with you on that. We're past that.
All right, so my point is that when she talked about individuals, though, she talked about how the study applied to assassinations. The study was not developed in any way, shape, or form
It's
to
called
look at
vanity press.
this sort of instance.
Let's be careful here. I think there's a side of the V that would call this an assassination of a non-political figure, but nonetheless, stay focused with me. Why wouldn't...
All right, let's skip ahead to him giving his sort of result.
Exclude her entirely. I'd have to say that there is no set of circumstances in this case under which her testimony would be helpful to the trier of fact, and you haven't carried that burden.
So you're saying that in your view, the only way her testimony could be relevant is if the defense says this kind of murder would only happen in an enraged emotional state.
Yeah, or in response to a threat.
Or in response to a threat. That's the only way this is coming in.
Right. That seems to be correct. Tell me why that isn't correct.
Well, I don't know that we really even have a problem if that's the court's ruling, that it's only coming in under one specific circumstance.
And this is the thing, is the defense at the end is like, well, we're listening to the judge getting to the ruling. We can go back if you want, but what the judge ends up saying is that this evidence only becomes admissible in the event that the prosecution, that the defense makes a very specific argument. And so the result of that is that the defense is not going to make that argument. And I don't think they were planning on making that argument in the first place. But what does that sort of mean? If the defense argues that the only way she'd do this is if she was being attacked. So, that means that this can probably come in if they try to make like a battered spouse argument. But I don't think a battered spouse argument is going to fly here. I don't think that's the argument the defense is looking at in the first place. I think the defense is like, I think the defense plan is basically to say this guy took some drugs and the drugs killed him, and maybe Kouri Richins was getting him the drugs because he had a drug issue or he had a drug issue and she was getting him drugs and he took too many drugs. And then, he died because, fentanyl is super dangerous, right? I could see that argument, right? I could see that being the defense's position, but I think the defense is going to have a real hard time arguing that this is like a battered spouse thing or something like that, because I don't think they're going to, I don't think that one's going to fly. I don't think that's going to be the argument that the defense is going to run. So the judge is like, I'm not going to exclude this witness entirely, but I will limit this witness down to such a narrow sub-argument that the defense is like, cool, that basically just excludes this witness. That's what we're looking for, right? And so I think that's really helpful to the defense. I think the defense essentially wins this one, and they say as much. They're like, well, you're ruling against us, Judge, but we're not upset by this, right?
Our general objection, though, is just not reliable under 702 under any circumstance. It doesn't matter what the circumstance is. I think that...
This is why I'm not persuaded by that. The defense keeps, at least implicitly, taking the position that if two people could apply this framework and reach different conclusions, it's not scientific, it's not reliable. Is that one of the defense arguments?
Well, one of many.
Sure.
It's not...
Now, that would mean that every physician that testifies in a medical malpractice case is unreliable, because in every single medical malpractice case, there are competing expert testimonies regarding the standard of care and whether it was breached. And they're both admissible, and it all goes to weight, not admissibility.
I thought about that as I was listening to her testimony, and I think the difference is, and I don't do medical malpractice, but I think the difference is when we have competing medical experts, it's typically based on actual scientific research and knowledge, and
Or
they
their
might have
education,
different
training and experience. They're not citing studies most of the time.
but it's based in science. You can get two experts.
I'm in Edmonton, Alberta, and the problem is that we allow expert evidence on such thin bases now. I feel like there maybe should be a different standard for criminal than for civil, but yeah.
Experts who have a different opinion when they apply the science, but this isn't any applied science of any kind. This is just a completely subjective theory.
But the law enforcement expert Diaz wasn't applying science either, but he was offering specialized education, training, and experience. That's the subject of Rule 702.
Well, he was not an expert, that's true, but he was
And you
applying...
thought he would have to be qualified as one in order to say what he said.
I know we see that in federal court all the time. They're applying their own experience. I am a DEA agent. I have arrested 1,000 drug couriers. Of those 1,000, the vast majority fit these characteristics. That's very different than what Ms. Amon wants to testify to. It's very different.
I think the rigor of Ms. Amon's testimony is greater in terms of, here are the studies. We looked at killings that actually occurred, identified these factors. We've published it. We've added it to the model. This is how we use it, full stop.
But none of those studies, well, first of all, she really didn't tell us what any of those studies were, but.
It goes to weight, and Dr. Fox will be able to tell the jury why this isn't going to help you make these decisions.
That's correct. But if none of the studies have to do with the domestic violence case, how is that helpful to the trier of fact?
Because if you're going to make a categorical people don't murder people this way statement, it has nothing to do with domestic violence anyways.
And I think one of the other problems is when she stated you can go.
That's the thing, is he's like, you cannot make the argument of nobody does a planned and deliberated murder. And the thing is that would be a stupid argument anyway. Why would anybody ever go into court and be like, nobody commits planned and deliberated murders? And I'm like, well, everybody knows that planned and deliberated murders happen. Like, it would be such a stupid, argument. And I see people quoting this, and I see people have said that this is apparently a Legally Blonde reference. And if it is a Legally Blonde reference, then Legally Blonde includes at least one stupid statement, because happy people do sometimes kill husbands. Happy people do sometimes kill their wives. Happy people do sometimes, commit murders because they want something, right? Yeah, I mean, there's always a reason, but yeah.
All the way down the pathway of violence, and then they don't
I have never watched Legally Blind,
So how is
or Legally
that even
Blonde,
helpful?
rather.
That increases the reliability of her testimony instead of decreasing it, because it acknowledges that there are people on the pathway that fall off. So it's a most, not all, a la Diaz.
Okay.
Defense counsel really needs to learn an important skill. The important skill is, and this is a tough one for defense lawyers to learn, you have to learn to shut the fuck up sometimes, and especially when you are winning. When the judge gives you everything you want and you are happy with the result, you're happy with the ruling, the judge has said, listen, I am going to give you what you want, and you're okay with that ruling. Shut the fuck up, because you can absolutely talk the judge out of, and I feel like she's in danger of doing this. She is in danger of talking the judge into a position that's worse than the position she's got right now, right? And so you got to learn to drop it sometimes. And you got to learn to drop it when you're winning. You got to learn to drop it when you're losing. And yes, there's an example. Bob Alessi. If you watch the Karen Reed trial, there are several moments when the judge is like, Mr. Alessi, I'm going to give you the remedy you want. And he's like, okay, I'm done talking then. And he sits his ass right down. And I just, love to, I loved seeing that. I remember praising Alessi at the time for saying, look, he is sitting right down. That is exactly what you need to do. She is not doing the Alessi. She is not sitting down, and she needs to be sitting down right now. Like, so much. And like, she is laughing back at the judge. I'm like, no, 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 no. Do not piss the judge off by getting fighty. Do not. Yeah.
You're going to want the last word because I think
All right, I'm good, yes.
my ruling here. Ms. Sherman.
Your Honor, I don't know that I have much to add. I think that the type of testimony that Ms. Amon would
And the prosecutor also shut the fuck up, because you're not going to move him out of his position. So unless you want to come in hard and argue that his ruling is like way off, yeah.
offer fits squarely within 702. She has specialized knowledge that would assist the trier of fact in making a fact of consequence more or less likely, and that they, being the jury, could use the analytical framework of the pathway to violence, taking facts that they've heard presented or theories that they've heard presented through witnesses and applying them to a framework that Ms. Amon lays out to understand how a person in a position commits a murder under certain circumstances. That testimony assists the jury in understanding how this case could play out, how it explains a theory or rebuts a theory put forth by the defendant about how this murder was committed and why it was committed. And the jury can use the framework that she presents or wholly discount it if they find it doesn't apply, and that would be up to the jury to decide. But given the type of testimony that Ms. Amon proffered and that we expect her to present as a rebuttal witness, it fits solely within 702, and for those reasons it's admissible.
Okay, I understand the state's position. Ms. Lewis, anything further?
I guess my last word is just that under 702, I don't see any scenario under which this is a reliable science that could be presented to the jury. And I also don't think the testimony was that the pathway to violence is a most. It's an occasional. It's a few. So I don't think that they're to admit this is reliable under Rule 702 in any matter, I think is inappropriate.
Okay.
All right. That should have been half the time. Her last word. Her last word should have been, Your Honor, I reiterate my position. My position remains unchanged. This witness has testified to something that happens sometimes in some cases, not most in most. And we reiterate that position. It remains the same. Sit down just to preserve the issue for appeal. That's it. You want to, like, that last word has got to be real last word. So, yeah.
The issue before the court is whether Ms. Amon's proffered expert testimony should be excluded in its entirety. The motion is made under Rules 702 and 403 of the Utah Rules of Evidence. The court addresses Rule 702B first. It provides that scientific, technical, or other specialized knowledge may serve as the basis for expert testimony only if there is a threshold showing that the principles or methods that are underlying in the testimony are reliable, are based upon sufficient facts or data, and have been reliably applied to the facts. Here, first, it bears noting that Ms. Amon is being offered as a blind expert. She is speaking about general principles, not applying a framework or analysis to the specific facts of this case.
Bullshit. I mean, obviously, when the jury hears it, they're going to apply it to the case, right? So, yeah.
Moreover, her testimony is based upon a retrospective study of killings that actually occurred. And based upon that retrospective study, her testimony identifies some commonalities that exist among completed killings, while also acknowledging that people that begin on the so-called pathway to violence often fall off at any of the stages, sometimes begin again and then fall off again. That just because they begin on...
Yes, because beginning the pathway to violence, according to this, is I am pissed off about something. Okay, cool. Yeah, okay. Awesome.
The pathway does not predict or mean that they will complete a killing. Under Rule 702A, the court finds that based upon her education, training, and experience, as shown in her CV, Ms. Amon is qualified as an expert in this field, and the court finds that her testimony based upon that retrospective study is sufficiently reliable and based upon a sufficient set of facts or data, given her description of those retrospective studies and their updates over time, to satisfy the minimal threshold for reliability under Rule 702B for a blind expert. The real issue is whether her testimony would be helpful to the trier of fact under Rule 702A, and under what circumstances. To be clear, under cases like United States versus Wells, 879 F. 3rd 900, which is from the Ninth Circuit in 2018, Ms. Ammon's testimony cannot be used by the state in its case in chief as substantive evidence of guilt. And even if she's called as a rebuttal expert, the state cannot refer to her expert testimony as a basis for the jury to draw comparisons that would weigh in favor of a substantive finding of guilt.
So those two rulings, I mean, they can't use it in their case in chief. Cool. They can't call her in case in chief, right? However, the judge is also saying if they use her as a rebuttal witness, and if they make certain improper arguments like that this indicates guilt, that this could blow up the case. So now he's basically setting mistrial minefields. I like Legal Byte's take on the CoffeeZilla lawsuit right now. I didn't cover the CoffeeZilla. It's one that I regret falling behind on. And so I keep debating whether I should go back and start covering it again because I like CoffeeZilla. So, yeah.
However, in the event that the defense makes an assertion in its defense case that is categorical and general, for example, something to the effect of that it's simply not credible that a person would engage in a weeks-long campaign to kill another person in the absence of an imminent threat to their safety, then Ms. Ammon's...
Why would anybody ever make that argument, right? It's if the defense makes this very limited, and stupid argument, then yeah.
Testimony regarding the retrospective study of completed killings, showing a feature such as a preparation and plan over time would be helpful to the trier of fact under Rule 702A to rebut that generalized categorical assertion by the defense. If the defense makes an assertion to the effect of Kouri Richins did not commit these crimes, and one of the reasons you can be sure of that is because Kouri Richins had so much to lose in her personal life and her family life if she had. That is a case-specific level that Ms. Ammon's testimony would not be helpful in rebutting. However, if the defense makes a absolute or generalized categorical statement regarding how homicide unfolds or whether it ever unfolds as alleged in this case, Ms. Ammon's testimony would be helpful to the trial of fact in rebuttal. And it would not be unfairly prejudicial in a way that substantially outweighs its probative value, because it would not be able to be used by the state as substantive evidence of guilt. Rather, it would only be used to rebut the defendant's categorical assertion regarding features related to homicide. The court acknowledges that pursuant to this ruling, the likelihood that the defendant is going to make such a categorical high-level argument is pretty low, which means that the likelihood that Ms. Ammon will ever be called to testify is also pretty low. But the fact remains that there is not a basis to grant defendant's motion in full because there is a cognizable basis upon which her blind expert testimony would.
So basically, he's saying, here is the red line that will let the prosecution call this witness. And he quite reasonably says, well, it's unlikely that, it's unlikely that anybody will, that she'll need to be called, because why would the defense do this? And, yeah.
Be helpful to the trial of fact under Rule 702A, and which its probative value would not be substantially outweighed by the danger of unfair prejudice under Rule 403. So, the defendant's motion to exclude Ms. Ammon's testimony is granted in part and denied in part. She cannot testify in the state's case in chief. The state cannot use her testimony, even if it comes in rebuttal, as substantive evidence of guilt, either directly or by inference. And her testimony would not be helpful to the trier of fact to rebut case-specific assertions of why Kouri Richins did or did not commit the act she's accused of. However, if the defendant makes a categorical assertion regarding how homicides unfold, the court will revisit this issue to determine whether Ms. Amit's testimony should be allowed in rebuttal. Let me pause there for a moment. Ms. Shervinack, do you need any clarification of the court's ruling?
No, Your Honor.
Ms. Lewis?
No, Your Honor.
Okay. Ms. Lewis, where would you like to go next?
I guess we're, Mr. Throckmorton will be
Okay.
next, so Ms. Nestor will be, do you want to move or are you okay there?
Ms. Nestor, I have looked at Mr. Throckmorton's report from June of 2023 and his amendment in March of 2025. I'm really familiar with him from other cases in terms of his background and his method. Tell me what you see as the problem in this case.
So, Your Honor, can I come to the...
Wherever you're
I
comfortable,
hate bending
please.
over to
Yeah.
reach that microphone.
All right, so we're gonna wrap it up because I just wanted to look at the look at this expert here. We're gonna cover the super chats, and I mean, and you say, how does he control what the judge is going to, or what the jurors will infer? He's going to give the jurors a jury instruction if this witness testifies, which she probably won't. I think that this is very much likely that that this ruling ends up being a win for the defense, that the defense has successfully prevented this witness from testifying. But the judge has left a tiny little crack at, for how this could come in. But the prosecution is probably telling their witness, like, yeah, we might not need you. So, yeah. We'll have to see. That said, I'm going to be continuing to cover the Uvalde case as the primary case. We covered this because I watched this today because I thought that this was interesting with this particular witness. This witness kind of touches on an issue which has been a long-standing annoyance, which is bad experts, right? So that is a long-standing annoyance for me. And this, I was like, I have to rant. And I was like, how can I rant about this? Because I'm going to have to be covering the Uvalde stuff. And then the Uvalde stuff was like, all right, it is, we got this done in 15 minutes. So it's like, okay. Will I be covering it live? I'm doing it as recaps because that's what I'm able to do right now. So I'm doing it as recaps. I might have some days that I have to miss for recaps. In particular, there's a day where I have a court proceeding that we'll see, but yeah, we'll figure it all out. And yeah, what did the prosecution do to screw up the Uvalde case? Well, the prosecution brought in a witness who said some things in an interview with the police, and they failed to disclose that to the defense. So yeah. Got the Buick running yet? I have not. Nope. Nope. Bad experts exist everywhere, particularly with former military who were never issued or used pistols enough to be an actual authority on pistol craft, stealing, shooting, valor. You're not wrong. There's a lot of when I see somebody offering expert testimony on firearm stuff, if I see that their CV is former military, I'm like, yeah, this guy might be full of shit. So we'll have to see. There's a lot of ex-military experts who aren't experts, but just say, I was in the military, therefore I must know guns. And it's like, that's not how that works. At least this expert didn't cover themselves in blue paint and cosplay. Yep. All right. Must hit a goal. Ian will dehydrate. Thank you. I read somewhere Alberta doesn't have rats. Alberta does not have rats. Now I need to know how many you've seen in your life. Thousands. I grew up in British Columbia. British Columbia does have rats, and I have seen lots of rats in BC, but yeah. Moscow mules are great, but I'm partial to a gimlet. Gimlets are also great. At one event that I went to, I think I drank like 6 gimlets and then needed to go home. So yeah, it was fun. Jennifer says, thank you for covering this trial. Thank you. Mary Matilda May, for your educational coverage. I'm really enjoying your lives. Is it weird I'm learning so much about U.S. law from a Canadian? Cheers. I am learning a lot about U.S. law by covering and researching all of these things. Zora wants pizza. I owe you guys pizza bones. Pizza bones, but we love her and need her healthy. Sending her boops and hugs. Zora is going to get a piece of that. Wait, are rats? So are rats like something specific? Rats are like rats are a critter, right? They're a specific animal. They're a rodent, so like a mouse, but bigger. And yeah. All right, let's see if I can get the dogs here. I'm going to give Potter this piece. Zora is getting this piece. Zora's getting a little piece of, and she's going to be mad at me because she's going to see Potter getting the big piece and her getting the little piece. And she's going to be like, I know where you sleep. And so she will probably, when I go to bed, be like, I am shunning you, but I also want to snuggle because I like snuggles. So we'll see. There are still more super chats, but I owe you guys this. So yeah. All right. Puppies. Zora, Potter. Let's see if they come. Zora, Potter, I got pizza crusts. They might know that word. Zora, Potter. Nope, they are. All right, I have failed, so they will have to get that later. So yeah, we'll I'll maybe have to save pieces for another but yeah, they're probably gone to bed with Mrs. Runkle and not feeling like coming up. So yeah, that is sad. All right. Let's see. Got Supreme Court of Canada versus SCOTUS interpretations of common law. Yes. Yeah, we will do one at some point here. Drinky Drinks the Plum. I've had a couple of those. They're actually pretty decent. Vez from Quebec. I now prepare meals in Ziploc bags for the pups to avoid the Zora/chunk effect. More work, but that way I'm sure they don't get some extras. I think she's getting extras from like stealing from other dogs. So yeah. I feel like that's a thing. I'll keep giving 5 until we hit the goal. Then I'm going to lurk for the rest of the night. Well, thank you, Brentwood Chic, who then did a smiley face and goal. Thank you so much. David Craig says, I'm behind the stream, but from the US. Greetings and elbows up to our Canadian friends. Thank you so much. Meme Express says, I'm pretty sure a bite-sized pizza bone will make Chunky Zora angry. Can't believe our cousin Throckmorton's a potential testifying witness for this. Yep. She might judge me. Vomit Fountain says, just dropping in briefly. My work schedule changed, so I've been on the replay crew. Thanks for your coverage of this case. Thank you. Just to correct chat, USF is different from UF. I have my undergrad from USF, and our mascot is the Bulls. Awesome. I support you in your pro bono dream. Thank you so much. Mary Matilda May says, pizza bone for Zora. She will probably have to get that tomorrow. I work at the animal shelter. I prefer dogs over humans any day. Pizza bones for all our paw buddies. Yes. Hi, Runks. Did you tell Mrs. R how your chat chastised you for streaming on date night? She knows. Happy Wednesday. I have told her that I have to ask permission, not just from her, but also from the chat. And yeah. Analogy. This is like if Judd Welcher was only offered as rebuttal because Karen Reed's team claimed that the car couldn't have hit. because car bumper height didn't match to John O'Keefe's arm. Blue paint equals in. Yeah. Did you see the news article today about the buyback? Yes. Out of 200 guns, they collected 25. It's depressingly pathetic. Pattern recognition / behavioral analysis studies are the medical equivalent of horoscopes. Find 2 to 5 things that encompass 99% of the population. All BS. Yeah, and there is no reliable data or stats in bossing. Say, FBI in the 70s also used garden hoses to get info. You're not wrong. B is for Bob. Headed to bed. We'll be back on the rewatch crew. Thank you. Ohio Palm Moms is for the starving puppers. Please give Zora a small portion of pizza bones. I tried. She's gone to bed. For Dem Bones, I will try to. I will make sure she gets them. Did I miss Karen Reed sidebars on Monday? No, I was feeling like crap on Monday, so I didn't stream. And yeah, for the pups, thank you. Like I know cats are bungholes, but really. In solidarity from Pumpkin Pie, who's also chunky and on a diet he doesn't like. Maybe I shouldn't have named him after dessert. Morgan says, my brain has defaulted to Charlie Brown's teacher. Womp, 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 womp. Maybe Megan, maybe not, says, I feel like it's been a bit longer. Appreciate you as well. And Alphonse, make the doggos happy. The doggos are nappy right now. So Sharon Tietzel, thank you so much for joining up. Let's think about the dog, or thanks, not the cats. Goal hit to the pizza bones we go. Excellent. Jolene, thank you so much. Beamer, teal for the meal. Thank you so much. I'm waiting for the sighting of the Roman Empire. Yeah. Sue, thank you for the new membership. Much appreciated. I just need a latte. What I do know is I just loft sprayed my latte, and I know you're my favorite today. I'm a bit behind. Well, thank you so much. CS Tears, 6-year-old teacher shooting case example. Yeah. I don't know what's happening, but I'm happy to be here. Doggo picture break. I think we did a doggo swoop, and thank you for joining up. Welcome aboard. As a juror, I'd be pissed that they wasted my time with this BS. The juror isn't here. Like, the jury hasn't been seated yet. And so the jury is not pissed because none of this has happened yet. They don't get to see, and yeah. So remember how fast Alessi disappeared when Bev gave him a good ruling? Be more like Alessi. Yes, it is actually a really important trial skill. Here is the first $10 for you to watch Legally Blonde. So once upon a time, there was a plan to EDB and I would watch Legally Blonde because I've never seen it. I would still like to do that, but I don't know if it's going to happen. So I don't know. I got to decide. And I guess if I'll just watch it on my own, I'll have to figure out a way to do like a live watch, which would probably be something like I'm listening to it and I will tell you when it starts and you can watch along with it, but I can't play it on stream because otherwise I will get nuked. So we'll try to see about that, but I can't just watch Legally Blonde with you guys because I would get so nuked on that. So yeah. All right. That is all the super chats. Tomorrow there is going to be more of the Uvalde matter. So we're going to watch that or at least recap the good parts. And yeah. Beth Loves Things says, that is still the dang plan, Ian. I don't have the ability to make that happen. So yeah, you'd have to talk to other people because I I don't have the ability to make that happen. So yeah. All right. So thank you guys all for joining me. I'm glad you're here, and I will see you tomorrow. So good night, all.